after these amazing remarks, we're going to get underway here. Our next speaker is Anya Baker. She is a mom of a special needs child, and she is coming directly from Mississippi, the state where this is all unfolding, where she works with SBA List and her plan to make sure women are supported. Anya, please join me here on stage.
Welcome. We are live at the steps of the Supreme Court this morning. Very historical day in our nation's capital. Good morning, everybody. Brian Glenn here live, along with Father Frank Pavone, the Priest for Life, and the presentation just got underway behind us. We've got a series of speakers over the next several hours that will not only give their testimony to what has happened to them, but perhaps what needs to move forward in this pro-life movement. We're here once again. We were here back on November 1st covering the Texas Heartbeat Act. Now we're here once again for what a pivotal court case here at the Supreme Court, the Dobbs case.
It's very pivotal, Brian. This is one of the most important cases the court has heard on abortion. And here's in a nutshell the reason why. It goes right to the core of the question of whether states can protect the unborn babies. Mississippi, out of which this case arose, is trying to protect its children in the womb, starting at 15 weeks. And the courts for 50 years have said you can't do that. You have to wait until after viability. Now, to me, and I'm sure to many of our viewers, that has never made any sense, because if a baby is more dependent, the baby needs more protection, not less. If people say, oh, but the baby can't survive outside the womb, well, we say, well, that's why you keep the baby in the womb. You don't take the baby out. And so the court is going to look at this question. The court has agreed to reassess its prohibition of protecting babies before viability. That's why this is so important. Because if they say, yes, you can do that, there are a lot of states that are ready to do that.
Yeah, absolutely. Let's pan the crowd real quickly if we can. When we walked up here, obviously we were here for November 1st for the Texas Heartbeat Act. There was quite a crowd assembled here, but today would draw such a crowd, not only from the pro-choice, but also from the both sides obviously turned out today. Let's set the scene here as far as the tone of this event. You know, a lot of people have not been to a pro-life type organization. It's two sides to the political take here. One side's very about life, celebrating life, obviously a lot of biblical base. The other side seems very angry. Why do you think that is?
It's palpable. It's a palpable difference. Now, first of all, what we're standing in the midst of right now is not a normal pro-life demonstration, because what we have here are actually competing rallies. We've got this rally that we're standing in front of, the pro-life one, and then just to our right is a pro-abortion rally. And this is the way it usually is when the Supreme Court is hearing an abortion case. You have these two rallies right next to each other. So it's very noisy, it's very crowded, it's very tight, but this time, as you said, we have more of a crowd than ever before. The street is actually closed.
Which it wasn't before November 1st. That street was open. So today, that was the first thing I noticed. They closed the street because of the overflow that was being pushed out from the steps right here.
And people are still arriving. I know that there are some schools that are sending hundreds of students. This crowd is going to swell as the morning goes on. But as you say, this is a very, very joyful, peaceful crowd. I see a sign over there with a smiley face on it. You have families here. You have young people.
Medical professionals.
Well, we have medical professionals. We have lawmakers. Later on, we're going to be having members of Congress show up to speak. And these different speakers today represent the different people who have submitted arguments to the court by way of friend of the court briefs. So, for example, all these OBGYNs who are here, they submitted their own brief to the court, and they said, viability has changed. You can't make that a dividing line anymore. They showed the court the research about how babies feel pain. That's an important part of this case. So you've got the medical professionals, later on the legislators here, both from the Congress and also from the various states. They're here to say, we want to be able to do our job. We want to pass laws protecting these babies. The court isn't letting us do that. And so essentially they're saying back to the court, give us our job back. Let us legislate on this. So yeah, we'll have a nice array of speakers. Our own associate Alveda King led off the rally just a few minutes ago in prayer and in song. And we'll have various prayer times during the morning as well.
We talked yesterday how important protecting the blood of the innocent is to the prosperity of this country. Let's recap that real quickly, because I think there is a direct correlation between doing what I think God would want us to do and fight for and the prosperity of our nation.
Well, when you look at it biblically, why did the exile take place, whereby the Babylonians came and just took away the kingdom of Judah, burned the temple, destroyed the city of Jerusalem? Prior to that, the Assyrians had come in and took the northern kingdom, the 10 tribes, into exile. And when you read in the books of Kings why the exile happened, it was because of the shedding of innocent blood. This is a very serious sin. Scripture says God hates the shedding of innocent blood, and he punished the nations because of it. When we look at abortion, it's no different than the child sacrifice that took place and is condemned in the Old Testament. And Jesus talks about the value of the blood as well. So when we say God bless, we've got to say it with fear and trembling, because God is saying back to us, wash your hands clean. You think about Isaiah, right? That's prophecy in Isaiah. Wash yourselves clean. Put away your misdeeds from before my eyes. Cease doing evil, learn to do good. That's a big part of this case, too. Many of the briefs that were submitted sounded like Old Testament prophecies. There were religious briefs that were submitted. And, the religious groups that are standing here today are saying this very same thing, that if we want God's blessing, we've got to protect those youngest children.
Let's also talk about the situation at the Supreme Court right now under the Trump administration. He was able to add a few very conservative Supreme Court justices. How would that affect any type of oral arguments today?
It will affect it very much. First of all, it has affected it by the very fact that the court agreed to hear this case. There is no question that if we had not elected President Donald Trump, we wouldn't be standing here right now, because the case wouldn't have had enough justices to agree to hear it in the first place. That's number one. Number two is, the president's judicial philosophy, and that of so many people who voted for him, was that the judge or the justice should be concerned about judging, not legislating. In other words, we're standing here right now between the Supreme Court and the U.S. Congress. And what we're saying is national policy on things like abortion don't get decided in this building over here. They get decided in that building across the street. When President Trump nominated his judges, hundreds of them, including the 3 that sit on the Supreme Court now, he said, I want judges who are going to judge, not legislate. And that's an important distinction, because when you think about what the court is arguing today, well, is viability a dividing line as to when the state can protect babies? That's a policy issue. That's not a constitutional question. It's a policy issue. Who should draw that line in the first place? It should be the legislators, whether you're talking about a federal law or a state law. And so if, as we know is the case, the justices that President Trump put on the court, and also those that are still on the court now from George W. Bush and even George H.W. Clarence Thomas, in other words, we know what their philosophy is. They believe that they are judges, not legislators. That bodes well for this case, because Mississippi is saying, let us legislate. And so are the other legislators, like we said a moment ago.
So let's recap real quickly. The oral arguments begin at 10 a.m. here local time. Go for about how long?
There's about 65, 70 minutes of argument scheduled. Now, the court doesn't always start right on time. Sometimes they have some other business to attend to at the outset. So we'll see how that goes. Now, the justices also have discretion to allow the argument to go longer. So depending how it's going, we may see it go even beyond an hour and 10 minutes.
And it's interesting when you look at the midterms coming up. It's such a hyper-political environment that we have, where does abortion rank up on the priorities of conservatives and on the other flip side?
You know, various post-election polls in recent elections have shown that there is about 20% of the population who say the candidate I vote for has to agree with my position on abortion.
All right, guys,
and when you look at that segment of voters,
really quickly,
often by a margin of 2 to 1,
like
they vote pro-life.
We love babies.
So we
Yes,
know
we
that
do.
it is a deciding issue.
How
We know
about
that it is a
you?
politically advantageous
On
issue
three.
to
1,
those who are
2,
pro-life.
3.
And with
We
the
love
attention
babies. Yes,
that
we
abortion
do.
has gotten
We love
this year,
babies. How
both with
about
the Texas
you?
law and
Now,
with this case,
we love
it's going to be more of an
women.
electoral issue than ever.
And I think also when you look at all the other topics that are in the news cycle today, law and order, following the law, this kind of falls into a logical category of like, what is the right thing to do? What is the law-abiding thing to do? I think protecting life falls right into that.
It certainly does. It's the number one duty of government. The number one is to protect the rights of the citizens. This case really does bring us back to the Declaration of Independence. Why is government established? To protect the God-given rights of the people. And what's the first one? Life. It's clear. It's in black and white. The phrase right to life is right there in the Declaration. Abortion is nowhere to be seen there. And so, yeah, it gives us really back to the basics.
Let's go back about a year ago from today. You were a big part of everyone here on Right Side Broadcasting Network getting us through that post-election stress that was going on. Millions of people watched our broadcast with you, our live prayers. Let's talk about that for a moment and how many people come up to you and give you praise for basically being there for the American people when times did not look very positive. You know, there's a lot of stress.
I think back on that with such good memories because people do come up to me on all the travels that I make around the country and the events that we do. They say, Father, we were with you guys. We were with Right Side during those weeks of tension and uncertainty and sadness. We were there and you helped us. You got us through it. And you know, God bless the whole Right Side team that we all did that together. And one of the things we said during those weeks is now very helpful to recall. What we said was that the good work that President Trump did, for which all of us share credit because we got him in there, will outlast him. It will outlast his administration. And so we were saying, look, no matter how this turns out, we're going to see the good fruits of his work. Well, what's one of those good fruits? The justices sitting on this court. And so the fact, again, the very fact that we have this case and the very fact that we have solid reasons for confidence in the outcome of this case is thanks to President Trump and all those who elected him and supported him during those 4 years. So it gives us consolation, doesn't it, that right in the midst of such a, really the most pro-abortion administration now under Biden, we've got this potential imminent victory.
And when you look at what's going on under the Biden administration, all of the problems that we have in the world, not just the economic problems that we have in the world, but also the social issues that we have, the division between people and races and, you know, even unvaccinated and vaccinated. Like this type of collective organization here that we have to protect life and to honor God, I think is needed right now in our culture more than ever. Yeah, we have so much division right now.
It's true, you know, and one of the things that I always said about President Trump is that he was a great and is a great uniter. And what do we mean by that? Because many people say the opposite. Well, what we mean is he points us to the values, the principles, the rights, that constitute the identity of America. The right to life is one of them. That defines us as a nation. You can't unite unless you have something to unite around. You can't be together unless you have uniting principles that everyone agrees to. So in the sense that there will always be people who reject those principles, in that sense, there will always be division. And nobody's got to try to end that kind of division. But when you say, who are we united at least around that? The right to life is right at the center of bringing us together. And that's why you have, you know, when you talk about unity, You look at the crowd here. I mean, standing near us, there are pro-life atheists. There are pro-life people who call themselves Democrats. There are people of all ethnic backgrounds. There's a big banner here that says secular pro-life. I know them very well. They don't even believe in the religious arguments about abortion. Why are all these diverse people standing together here for the same purpose? It shows the unifying power of something so basic as saying we have to protect our children.
And throughout this broadcast, we'll give you guys an idea of what it looks like out here. It is absolutely packed. I mean, there's, like I said earlier, 10 times of what it was here about a month ago. But big day today, and we want to encourage everyone to share this broadcast. You know, if there's ever been a segment that we've ever done that could literally change history, we're looking at it. I mean, we've been there with President Trump throughout the 4 years. We were there with the inauguration. We were there when he left on January 20th this year. And this is one of those days that will go down in history that you can say, I was watching Right Side Broadcasting Network when this argument took place. Now, what the outcome will come from this, nobody knows at this point.
And Brian, you know what I was saying to a lot of the pro-life leaders during these days? Today is almost 50 years to the day when the oral arguments in Roe versus Wade were heard. They were heard in 1971 on December 13th. Now that's a week from this Monday. So is that not something that God is saying, right? Exactly 50 years later, the arguments are heard that could reverse it.
Yeah, God is definitely here today. So I want to encourage everybody to share this broadcast and also follow us on all of our social media platforms. Go download our app, which is wonderful because we know how tech censorship is. Go to your Apple, your Android store, and download our app and take this broadcast on the road with you wherever we go. Of course, your show airs nightly. It seems like like multiple times a day. It seems like because people share it, and which is a great part of our network. And we certainly appreciate the spiritual guidance you give us.
Thank you very. It's a joy to do it. I really, and all our Priests for Life followers love RSBN, and we're merging our audiences, and that's a great thing.
Well, I think there's a common core between the two audiences. I mean, people who just absolutely love President Trump and conservative values fall into this category, and the pro-life and a pro-life mom and the whole movement protecting life. So I think it is actually the right broadcast to do right now. And I told you this a couple of days ago that I think it's imperative for news outlets right now to cover this story, because if you don't expect you to be blessed.
No, that's right. And as they cover this story, keep in mind, obviously our viewers know this, the secular media always gets it wrong. This is not about abortion becoming illegal tomorrow or this court saying it's outlawed. It's about returning the process by which America works out its position on abortion to the duly elected representatives of the people, because they're accountable to the people. Unlike these unelected judges, we don't want them imposing policy on us. We want the people that we have working for us, the legislators, to answer to us for what they vote on in regard to abortion. That's what this case is about.
Okay, we're going to drop in on this conversation here in just a second, but we want to encourage everybody to go support our partner in all of this, the great Mike Lindell over at MyPillow.com. Of course, he has done so much for the conservative movement, so much for election integrity, and you know what? He supports this pro-life movement here. So we just want to encourage everybody right now to go get a jump start on your holiday shopping. Forget the delays and shipping, get the delays and fighting the malls and all that good stuff. Just go online to MyPillow.com. That's MyPillow.com. Put the promo code RSBN at checkout, and you'll get up to 66% off your entire order right now. You're talking Giza sheets, dog beds, slippers, those famous pillows. Go support the conservative movement of Mike Lindell and his company over at MyPillow.com. We'll continue to bring you all of the action outside here throughout the morning as the arguments begin at 10 o'clock inside. We'll have that audio streaming to this platform, but we'll have the video out here so you can see what's going on. So we'll have the audio from the oral arguments and all of the video coverage out here. So let's go ahead and turn it over to the microphone on the podium and listen in.
But today, we have an opportunity to bring healing. We have an opportunity to bring hope. You know, we need to come together around the science, around the research, around the technology. We know we can follow the development of a baby today in the womb, day by day, week by week. They're performing prenatal surgeries to save the lives of babies in the womb. It's all proof that life begins at conception, and it's worth living. As we continue our search for a more perfect union, I wanted to join you today in prayer. Would you join me? Heavenly Father, we thank you for this day. We thank you that you are faithful. We thank you that you have governed in our country all through the ages. We thank you for so many who've gone before us. And you know, today in the United States of America, I find myself reflecting on the times of Ezekiel and the prophet Ezekiel when he said, you know, our nation is lost, all hope is gone. We become old, dry bones. And yet you, the sovereign Lord, said, behold, I will pour out my spirit upon you, and you shall live. Lord God, you are the author of life. We know, Lord, that it is you that forms each baby. You form together our bones in our womb. You call us by name. Lord, we thank you and praise you, Lord, today for this day. We pray, Lord, that you will speak about life, about hope, and about healing in our land. In Jesus' name, amen.
Thank you. Wonderful, wonderful. All right, guys. Who here has seen the movie Unplanned? Who here has read the book Unplanned? All right, then you're going to know our next speaker. Monsi mentioned that there's millions of dollars in the abortion industry. I want to point out something really quickly. You guys volunteer your time and your talent for life. The side over there makes money off abortion, right? You are on the right side. And we now get to hear from a woman who came from that side to this side, and we're so proud of her. Please welcome Abby Johnson.
All right, well, I am from the great state of Texas, so howdy. I mean, we're always proud to be Texans, but now that we have the most restrictive abortion law in the country, we are really proud to be Texans. So, you know, for 8 years of my life, I worked at Planned Parenthood. As the director of that facility, I would happily educate women on the ease of abortion, glossing over any details of the procedure or any possible risk. I would walk them up and down the halls, escorting them in and out of the rooms as they waited for their turn to lay on a table that was still warm from the woman who had just taken their turn before them. After all, our goal was to have a woman on the table, off the table, abortion complete in 5 minutes. Time is money in the abortion industry, and we had a certain quota or number of abortions that we had to sell each month. The waiting room of an abortion facility is loud, like them, full of women and the people who they brought with them to their appointments, sometimes with their other children in tow. People are having lively conversations, often discussing their past abortions and giving encouragement to the other first-timers in the room. But every once in a while, I would be called to work in the loneliest room in our facility. It's often the loneliest room I often say it's the loneliest room I've ever walked into. It's the abortion clinic recovery room. A room lined with recliners and low lighting, silent except for the quiet sobs of women. And they all cry. They all cry. We didn't give them much time to dry their tears and steal their emotions. 20 minutes was all they were allowed. 20 minutes to convince themselves that the feelings they were experiencing were a lie. To convince themselves that abortion was normal, that they were only crying because of their hormones. 20 minutes to convince themselves that no, it really wasn't a baby. And we, the abortion clinic staff, gave them no comfort, and we certainly never gave them a shoulder to cry on. We never talked to them about abortion regret, because if we did, then we would be admitting that women actually did regret their abortion, and we could not do that. We handed them a tissue, left them to cry alone, gave them 1 month's supply of birth control pills, a can of apple juice, some graham crackers, and sent them on their way. It was another woman that fulfilled our monthly abortion quota. That was just the process of how we dehumanized the women that came through our facility. But the primary victim of abortion was being dehumanized in a far more barbaric fashion. While we were processing women by the dozens, like a farmer would process livestock, their preborn human children were being suctioned through tubes or being torn apart by the rigid teeth on the end of sofa clamps. Outside the doors of our abortion procedure rooms, you could hear the suction machines loudly whirring. The doctor would know the abortion was complete when they heard a very loud suction noise. That was the head being sucked through the tube, the largest part of the baby. After the procedure was over, their body parts were being counted and accounted for on pieces of paper with the appropriate check boxes listed for arms, legs, head, and torso. The products of Conception Lab look like an assembly line of baby body parts. At some facilities, these parts are put into industrial-strength garbage disposals and ground up. At our facility, they were put into red biohazard bags and then at the end of the day, put into a freezer that the staff jokingly called the nursery. This is abortion in the United States every day, approximately 2,500 times a day. This is what they are celebrating today. Abortion dehumanizes everyone it touches. It hurts women, men, families, and of course our most innocent, the preborn. Abortion also hurts those who work in the abortion industry. My organization, And Then There Were None, has helped over 600 abortion workers, including physicians, leave this industry. Women are wrecked inside these abortion clinic walls at the hands of an industry that cares only about their bottom dollar. None of this is about women's rights. This is about the right to harm every woman and child who walks through their doors. In 1973, we didn't know, but we know better now. And when you know better, you do better. When a product is deemed unsuitable or unsafe for the public, it is pulled from the market. Abortion is unsuitable for public consumption. Any product where its success is determined by the death of another human being, it should be pulled from the market. It is time for abortion to be recalled in this country. It is time to end abortion. And I just want to say on a personal note, because this is very personal to me, if you are a woman who has had an abortion in this crowd, I just want to say that I'm sorry. I'm sorry that you were lied to. I am sorry that people like me took advantage of you, that we coerced you, that we lied, that we didn't give you the information, that we abused you, because you know what? Abortion is abuse. It is abuse of women. And I am sorry that I was a part of that abuse in your life and the lives of so many other women. I am sorry that these women have been so deluded to believe that that abuse that took place in their lives is normal, because nothing about abortion is normal. That was not normal for them. It was not okay. And if that happened to you, I am so, so sorry. And I'm so sorry that I was a part of that industry. And you deserve healing. You deserve the very best. And if you haven't sought that healing, please do so today. Thank you.
Thank you. It's powerful. Thank you, Abby. Wow. We are the side of love, aren't we? Let me hear it. Send love to some women right now. I'm so grateful for you each being here. You each have a story of fighting for life, why you're pro-life. Maybe you're a medical professional here, and I'm seeing pro-life medical professionals, dignity for all of our patients. Maybe that's your story. I'm seeing signs that say, babies survive abortion. I'm one of them. We have people here that have survived abortions, like Melissa Oden, like Gianna Jessen. They are so human and so worthy of our protection. We have signs that say, protect me, I'm 15 weeks old. Let's go. 15 weeks. Let me hear it. 15 weeks. 15 weeks. 15 weeks. Now look, I want to save them all. We all want to save them all. Over there, they won't save any of them. Will they stop at 9 months? Will they stop at 8 months? Do they stop at 5 months? Do they stop if you survive an abortion? They never
Okay, we're going to
stop,
drop back out
and
here.
neither
We are
will
live at the
we.
steps
Let's
of the
move
Supreme
this
Court
this
of a
football
very
for all the guys
monumentous
here.
day
My
here in our
husband
nation's
appreciated this. He
capital. The
actually came
Supreme
up with
Court
it
will
wherever
hear
he is.
the
I
oral
love you.
arguments in the Dobbs case
move
coming out of
this
Mississippi.
ball down
I'm
the
joined once again,
field.
Father Frank Pavone, priest for life. You've been a huge voice here in the pro-life movement. You've got a very descriptive demonstration that will really tell the tale of what it's like to the baby to get an abortion. You got an example here.
Yes, Brian, we really have to. I've always advocated that we've got to bring the abortion debate out of the abstract and down to a very human, tangible level, so people understand what we're getting so excited about here. So Mississippi is talking about protecting babies 15 weeks into pregnancy. Now that means about 13 weeks after the baby is actually conceived. Okay. This is a model of a baby at approximately that age.
See that? Let's see if we can.
Forced himself on me and raped me.
Now, we're talking about a baby here.
How many weeks again?
About 13 weeks after conception.
He really was.
A baby like this
March went by
has a
and he
heart
took
that's
me,
pumping
yet I still
every
hadn't
day
had a
about
period.
26
I
quarts
was
of blood.
panicking,
The
thinking
baby's
that I was
heart by that
pregnant by my
time
rapist.
has already beat over
I was a
15
straight-A student,
million
a starter,
times.
a basketball
There are people who are
team,
not even
other
thinking
band
about the fact
musician,
that the baby has a heartbeat at
2
all,
years ago
but
to
it's
an
already
Ivy
beat
League
over
school.
15 million times.
I was thinking
This
of
baby
nothing
can
but
curl
abortion.
her
I thought a
tongue,
child would ruin
move
my plans.
in response to touch on
Well,
just about
word
every
spread
part of the body.
that I thought I was pregnant, and it
Over
eventually got back to
4,000
him.
different bodily
He found me
organs
and told
are
me,
present. All the
"Amy,
bodily systems are
you need to
present
get an abortion.
and functioning. And
drive you
what
and I'll
does
pay for it, but
what
you
does Mississippi
need
try
to
to
get it taken care of."
stop from happening to this baby? This is a pair
If
of
you don't get an
surgical
abortion,
forceps.
I'm thinking I
These
might
sort of
kill
forceps
you.
were actually used in real abortions.
I'd taken ninth grade
And what the
bio,
abortionist
so I
does is
knew
reaches
that a
in,
unique living
grabs
human being is created
the foot
in
of the
moment
baby
fertilization.
and literally tears it off.
Prior to
Baby's
that
still
moment,
alive,
I just hadn't
and
cared.
rips that leg off and pulls
But
it
when my
out,
own life was
rips the
threatened,
other leg off, rips the
despite my
arms
fear,
off,
I suddenly
takes
and
the torso
begrudgingly
out
became
piece
pro-life.
by piece. This
Because
is
I
the
knew I could
dismemberment of a
never
living baby.
participate
And
in
then takes
violence.
the head out, not as a
I
whole
knew
piece,
that I
but by
couldn't be
fragments.
like my abusive ex
Now,
and pass on
how
aggression
anyone can
to
say
another defenseless
that this
human.
isn't violence against a human
in that
being
moment of fear,
is
I also understood
unthinkable.
what so many
You have to be
women go
denying
through,
reality.
as they are coerced
And many
into
people, I
abortion
mean,
by
these people
partners,
over here on this side,
families,
they would
academic
never
or business
describe
institutions
an abortion the
who
way that I
just
just
accept
described
the
it. But if you
patriarchal
look in the
idea
medical
that the
textbooks,
cisgender, wombless
this is
male
exactly
body
what
is
you'll
normative.
read about. So when we're
crisis
talking
of
about
crisis
people about what's
pregnancy
going on here,
exists
don't let them
because
get you
our
into
world
abstract
sees women's
discussions
bodies
about,
as
oh, this is
aberrant.
women's rights.
In
Before
that
you start
view,
talking about women's
menstruation
rights
is
or even
disgusting
the
and taboo.
Constitution,
We shouldn't talk about our
challenge them to answer one
Pregnancy
simple
is a
question.
disease condition
What
and
is
burdensome.
an abortion?
And
Can
a
you
child,
describe it
rearing a
for me?
child is
Because that's what the people over
inconvenient
here
and
on this
abnormal.
rally next to us and all
This
those that are
sexist norm
going to argue to the
leads
Supreme
to
Court
zero
today that they should
mandatory
strike
community.
down the Mississippi
Expensive
law
maternal
and that they
health
should
care,
uphold Roe v.
pregnancy and
Wade.
parental
They're going to talk
discrimination
about, I
in the
guarantee you, when we hear the oral
But
arguments in a little
menstruation,
while,
pregnancy,
the other
and
side is
childbirth
never going to
are
say
not
the word
atypical
forceps,
experiences.
legs,
They are
arms,
literally the
skull,
processes by
blood,
which
bones,
each and
crush,
every
dismember.
human being, literally
26
every
quarts of
human
blood that's
here
being
26
pumped. That's a
quarts.
lot of blood.
Every day that this little baby is
Alas,
pumping.
we live in a
The other side will never use those words.
Jumps to violence
In the briefs
as an
that have been
answer to
submitted
crisis
from the other
instead of
side, you'll never
addressing
see
the
any of those
root
words.
problems with
But the
creative
people who
nonviolent
like
solutions.
Abby just spoke. Abby and I have a very long, close relationship. In fact, I'm godfather to one of her children. And she came to me after she came out of the abortion industry and said, how do I heal? How do we help others heal? And we walked through the process of healing as she is now helping so many others do. But one of the things they have to heal from are all the lies that they told themselves about what abortion is. And they had to face up to the fact that they were doing this to little babies. And when they healed, she was talking about the ex-abortion workers. You know what they have to do? They have to count, as part of the healing, count the number of little lives that they took and ask God's forgiveness for each and every one of those lives. And that's what all of us need to do. We may not have been involved in abortion directly, but it affects us all. Going back to like we were talking before, biblically, when innocent blood is shed on the land, one of the things they're talking about the forceps in the bodies. But one of the things that Scripture teaches is that when the blood is shed on the land, everyone on the land has to answer for it. And that's why we're here. We're answering for that blood. And we all have to ask God's forgiveness for each and every one of these babies that have been killed.
You also described how quick this process is. It's a 5-minute abortion. So these ladies are in and then out, and many times the surgical table is still warm from the previous woman. Let's think about the psychological damage that these women go through when they leave the abortion clinic. They're given some birth control pills and maybe some type of pamphlet to get them through something, but that's it. They need resources like you and resources that help women get over such a traumatic experience in their life. They don't tell them how much post stress they're going to get from this.
It's psychologically devastating. First of all, there is a terrible loss of self-esteem. There is a terrible loss of confidence in themselves because they realize they've crossed a line that none of us is meant to cross, namely killing our own children. And once they've realized they've crossed that line, they start questioning themselves, what else am I going to do? What other evil am I capable of doing? And then it's the spiritual dimension. God must hate me. God must reject me. They go through difficulty now in making decisions. because they said, I made such a bad decision, then what other decisions am I going to be able to make? And the point is that the distress is something that nobody tells them about ahead of time. We try to warn them about it. But then we pick up the pieces afterwards. You know, one of the biggest things that we and many of the other groups that are here do year after year, day after day, is provide the healing to those that have had abortions, give them the counseling, and tell them that there is hope for them to go on with their own lives. But it's a steep hill to climb because there's a lot of wounds that they have to overcome.
Let's give you an idea of the crowd size right now. If you're just now joining us, we are live on the steps of the Supreme Court on what could be a very historical day in our nation's capital. This gives you an idea of the size of the turnout today. Very much bigger than the November 1st rally they had here for the Texas Heartbeat Act. But you've got basically two sides of all of this. You've got the pro-choice side over there, you know, and you've got obviously the pro-life side here. Many homemade signs from different organizations, political signs here. It really sets the tone of what this event looks like.
It really is. This is a cross-section of America, cross-section of the arguments that are used to end abortion. It is a cross-section of the many groups, the diverse groups of the pro-life movement. It's a cross-section of the political life of America, the professionals that are here from every background. It really is a microcosm of what our whole country is about.
We're about 15 minutes away, thereabouts. You said earlier, and they sometimes don't ever start on time, but 10 o'clock is the tentative start time for these oral arguments. If someone missed it earlier, let's lay out the progression of the arguments and what will be heard today.
Yes, here is what Mississippi is asking of the court. They're saying, first of all, you should not tell us in Mississippi that we cannot protect babies prior to viability. What you should do instead is uphold our law as something that's reasonable. And why are we asking you to do that? Number one, because abortion is not in the Constitution, nor is there any indication in the Constitution that the states should be limited in legislating on abortion. Number two, you should get rid of the precedents, Roe v. Wade and Planned Parenthood versus Casey. Now, these are the two main cases before today. The court has ruled dozens of times on abortion. But Roe v. Wade, and what you'll hear a lot is this word Casey. You'll hear it during the oral arguments. Casey was decided in 1992. Pennsylvania, like Mississippi, had passed a number of pro-life measures, and those were measures that had to do with parental consent, informed consent, waiting periods. In other words, that someone going to get an abortion should be given certain information about the procedure and then have to wait a while, maybe a day or two, before she actually has the procedure. So it gives her a chance to reconsider it, reach out to people in her life who could give her good advice, maybe find some alternatives, etc. So the Supreme Court actually upheld those aspects of the Pennsylvania law. But they didn't go so far as to reverse Roe v. Wade. Many thought that they might at that time. This was 1992. But what Planned Parenthood did do is it weakened Roe v. Wade. It lowered what's called the standard of review. Roe v. Wade tried to say this is a fundamental right. You cannot restrict it any more than you restrict freedom of speech or freedom of religion. Casey said, no, it's not at that level.
It's misogyny.
You can pass a law that regulates abortion like Pennsylvania did at that time, as long as it doesn't introduce an undue burden on women to have an abortion. So when we hear the oral arguments, we're likely going to hear a lot about this undue burden. Because what Mississippi is saying is you should get rid of that because it doesn't work. Why? Because it's not defined. It's not clear what the justices mean by an undue burden. One judge can say this is an undue burden. Another judge can look at the same law and say it's not an undue burden because it's a value judgment. It's an opinion. Undue burden is not a standard. It's a conclusion. So you're going to hear Mississippi argue that this is the word they're going to use is unworkable.
Nominated by the Equal
And that's one
Rights
of the things
Party
that the court looks at when they consider reversing a long-standing decision. They're going to ask, has the decision been workable? In other words, has it given the lower courts reliable guidance? Has it given the state legislatures reliable guidance on what kinds of abortion regulations are constitutional? This has proved unworkable simply because there's been so much confusion and so much disagreement and so much inconsistency. That's one of the legal arguments. Mississippi will also make the case that Roe and Casey have inflicted profound damage. Now, we were just talking about the damage done to the babies, the damage is done to the mothers, but they're also going to argue it's done damage to our court system. Look, for example, at what we saw at the confirmation process for Brett Kavanaugh. It was wild, right? It was absolutely wild. And what was fueling all of that, as Carrie Severino and Molly Hemingway say in their book about the Kavanaugh hearing, what was fueling it all was the abortion issue. The only reason abortion would fuel controversy at a judicial confirmation is because the court has given it this special constitutional status. It hasn't given this status to appendectomy, heart surgery, or anything like that, but only to abortion. And Mississippi is going to argue to the court in a few minutes from now, hey, listen, abortion shouldn't have any more constitutional status than any other procedure. Lower the standard. The only constitutional standard that a state should have to worry about when it legislates on abortion is what it does with everything else. Do we have a legitimate interest that we're trying to advance? And does this law relate reasonably to that interest? Those are the only questions a state should have to answer. So you're going to hear them argue today that the court should lower, simplify, if you will, make more consistent with all the rest of the law, the standard of review when it comes to abortion.
You know, go ahead.
Yeah, go ahead.
I was going to say, you know, yesterday was a National Day of Repentance, and we had a great ceremony at the foot of the Lincoln Memorial, and it was asking people to basically pray, repent for their sins. A lot of women who have had an abortion suffer the mental. I just want to talk about prayer for a second and how big this is in this overall movement right now and in our country.
Well, the people of the pro-life movement are people, by and large, who believe in the power of prayer. We have prayer vigils going on every single day in front of abortion facilities throughout this country. Many people partake in the 40 Days for Life. That's just one of many different prayer campaigns that are held at different times of the year about abortion. People pray in their churches about this, of course. We need more of that. But prayer does constitute the foundation of this movement. And when you think about it, the whole attitude of prayer is exactly the opposite of the attitude of pro-choice. What do I mean? Pro-choice says, it's my decision that matters. I assert my rights and my will. The attitude of prayer says, what God's will, what God's choice is what matters. And we put God first. We put God as the center of gravity when we pray. Thy will be done, right, is at the heart of every prayer. So just the mindset of prayer is undoing the mindset of abortion. And then prayer has an effect. It changes things. And we wouldn't be here today if it weren't for the prayers of people in this movement for decades.
When you look at the pro-choice side, what percentage of people do you think are grounded in prayer in every day of their lives? I know it's a wide assumption. I know it's hard to and maybe unfair to a blanket statement, but it seems like if someone is truly grounded in their faith, how can they be pro-choice of killing the unborn?
Well, let me make a connection here that actually the Pew Research Center made not long ago. They've done research on how people's views of faith align with their political views. Now, we already know that how their political views fall says a lot about their views on abortion. The Democrat Party is pro-abortion. And that's not to say that there aren't a lot of pro-life Democrats out there. There are. Some of them are right here. But by and large, you've got a very strong alliance between the Democrat Party and the abortion industry. On the other hand, when you go to Republican events, you find people of prayer. You find people of faith. Pew Research actually did an analysis, pretty much in-depth analysis, of the fact that the Republican Party is attracting churchgoers, people who pray every day, people who read scripture every day, people who put God at the center of their lives. They gravitate to the Republican Party. Where do the people gravitate who do not read scripture, don't believe in the Bible, don't believe in prayer, don't go to church, don't even believe in God? No question about it. They gravitate to the Democrat Party. I say that to put a context here that, therefore, those that support abortion will tend to be less religious and less prayerful.
And I also think that it seems like the Democratic Party seems like your rights are given by the government. They're not God-given rights. And so it seems like that's the biggest push to get people to not basically look at God as their center of existence, but the government, serving the government is their center of existence, and that's what keeps them ingrained and dependent on the government. If we can get more and more people dependent on the government and not putting their faith in God, then that becomes, it just builds their followers.
Well, that's so true in terms of their faith in God, and by extension, their reliance on the churches. Because when we look, for example, in the Trump administration, we would get phone calls all the time. And they would invite us to hop onto these conference calls with some of the leaders of the federal agencies. And the point they were making to us is, we want to help your ministry. That we would literally get these calls. We want to help your ministry. We want you to know that if you want to contract with the government, to serve the poor, help the homeless, we want you to know that because you're people of faith, you don't have to jump through any more hoops than do the people who have no faith. And when you do the work in serving the poor, you don't have to hide your faith. You can profess it. The Republican administrations are the ones that say that. The Bush administration said that very strongly. The Trump administration and future Republican administration will do the same. We believe in the role of the churches in America. The Democrats don't.
Yeah, and that's big. Think about how much good the churches of America do, like you said, for feeding the homeless, feeding the poor, being there when someone comforts someone in terms of death. The churches definitely be there. We're about 5 minutes away from these arguments in the Supreme Court to take place. I'm sure they will lead us in prayer. I'm thinking before that starts. That's very important. But right now, it's important for everyone to share this broadcast as much as you can on whatever platform you're watching us on, Facebook, YouTube, our app. Rumbles have been a great resource for Rumble. We during the campaign, we saw exactly what can happen there. So share us on Rumble as well. Go subscribe to our YouTube channel. And also, where can people get more information? If this is the first time they've ever said, hey, this is the first time I've ever seen Father Frank here. I'm not sure who this guy is, but I love what he's saying. What is the best resource for someone to get information on you?
Well, if talking about websites, it's endabortion.us, endabortion.us. And then on social media, they can find me at FR Frank Pavone on Getter and Parler and Instagram, YouTube, Twitter, and then on Facebook, it's Father Frank Pavone. Love to be connected with everybody.
And social media is a great way to share content. I have noticed, though, subjects like this, abortion, pro-life, is one of those topics that I think big tech wants to have their thumb on as far as suppressing information. So that's why it's as important as ever to share this broadcast, to get it out to people, because now is the time for change and to use this platform for the better good. Our sphere of influence goes a long way.
Can you imagine, I often think, Brian, if St. Paul had these tools at his disposal, how enthusiastic he would be. He endured shipwreck. He endured hunger and thirst and persecution and death threats and prison to go out and proclaim that gospel. And he did everything he could to reach the world. And we've got these tools at our fingertips. We know that people misuse them. But the fact that somebody misuses them is no reason for us not to use them for good and for the gospel.
Absolutely. We also want to thank our partner, Mike Lindell has been a great partner in all of this. And, of course, he is an advocate for election integrity. He loves this country. He's a patriot. He's also a big supporter of the pro-life movement as well. So we're just encouraging everybody to go to his website, mypillow.com, and support his products, buy his products, put that promo code in at RSBN at checkout, and you'll get up to 66% off. Because I think it's important that we support these companies that have really put their neck out there on the line.
You know, I was with Mike at Mar-a-Lago not too long ago, and he is a fantastic man. Just you know, his courage is contagious, and his support for President Trump and for this nation and for pro-life is exemplary.
I mean, think about days after the election, who was the one that was claiming that there was election interference? There was some discrepancies. It was Mike Lindell. It wasn't anybody else. So he has been out there. So we just want to make sure everyone supports him and his company because it's important that we support patriots like him. So go do your Christmas shopping. I know we got the shipping delays out there and the supply chain issues. Just work around that stuff and just go straight to the website.
Exactly, yeah.
We started any of your shopping yet?
Yeah, I've started. So, yeah. No, we and there's so many people who are supporting us, too. We're so grateful for, like I say, I meet them in my travels all the time, and we know that they're out there. You know, they can see us, we can't see them. But when we go out on the road, we meet them. I love meeting them at the rallies, too. At the Trump rallies, oh, my gosh, that's a lot of fun.
A lot of fans of Father Frank and a lot of fans of Mike Lindell as well. So go check out the website, mypillow.com, put that promo code RSBN at checkout, and get up to 66% off. All right, so local time here. Let's walk us through here real quick. We're sitting at about 9:58. This was scheduled to oral arguments to begin at 10 a.m. We're not sure exactly that will start about at 10 a.m., but therefore, for the most part, we'll run about an hour and 10 minutes, right?
About an hour and 10 minutes, and so that people understand how this works, each side has about a half hour to argue their case. So what happens is that the attorney arguing the case, and for the side of Mississippi, it'll be the Solicitor General of Mississippi, they will begin addressing the justices, and hopefully the justices will let them go for a while, you know, to make their argument, but they can jump in at any time with questions. One of the things that we will notice is that Justice Clarence Thomas has been asking more questions. He's been on the court 30 years, and for the longest time, he didn't ask any questions during the oral arguments because he has a different philosophy. He says, listen, we ask these people to come in to the court. They know the case better than anyone else. We should listen to them. We should listen to them. Other justices, you know, the lawyer will start talking, and 10 seconds in, they're interrupting them with questions. It's very, very hard, very challenging to argue before this court. But we'll hear both sides get 30 minutes. Here's another thing people should understand. The Biden administration has asked for 10 minutes of argument against Mississippi, against the baby.
Well, that just goes back to what we were saying earlier about the Biden administration. Wow, I did not know that.
Yeah,
get some time today.
The sitting president always has the option.
I would think if Trump was there, it'd be the same thing.
Well, he did actually. Trump's Solicitor General did argue on the pro-life side of the abortion cases, and that's something people should know. All right, so let's see what's going on here.
Supreme Court right now.
Okay.
Our AV team is going to connect us, and you're going to hear.
Before we do that, could you lead us in a quick prayer as we go on?
Lord, send your Spirit now upon this court.
Listen in now.
We submit the Supreme Court of the United States to the Supreme Court of Jesus Christ. Lord, each of the chairs of these justices is a different size and shape for them. And we know that each of them needs a particular size and shape of grace at this moment. For those who are pro-life, those who are pro-Constitution, Lord, strengthen them and help them to be persuasive to their fellow justices. And for those on the court, Lord God, who are supporters of the abortion industry, we pray that the arguments today will at least soften them to the extent that they can allow laws like Mississippi has passed. Give wisdom now to those who are arguing before the justices. Help them to say exactly, Lord, what you would have them say for success. And here we go.
Here we go. In Jesus' name, amen. Let's bring our audio back inside the Supreme Court.
We will hear argument this morning in case 19-1392, Dobbs versus Jackson Women's Health Organization. General Stewart.
The court. Roe versus Wade and Planned Parenthood versus Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a abortions before viability. It is unconstitutional no matter what. Roe and Casey's core holding, according to those courts, is that the people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey. That is not the world the Constitution promises. The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone, and when the Constitution does not take sides on it, it belongs to the people. Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. I welcome the court's questions.
General Stewart, you focus on the right to abortion, but our jurisprudence seems to focus on, in Casey, autonomy, in Roe, privacy. Does it make a difference that we focus on privacy or autonomy, or more specifically on abortion?
I think whichever one of those you're focusing on, Your Honor, particularly if you're focusing on the right to abortion, each of those starts to become a step removed for what's provided in the Constitution. Yes, the Constitution does provide, protect certain aspects of privacy, of autonomy, and the like. But as this court said in Glucksburg, going directly from general concepts of autonomy, of privacy, of bodily integrity, to a right is not how we this court traditionally does due process analysis. So I think it just confirms whichever one of those you look at, Your Honor, text is supplying a substantive right.
You say that this is the only constitutional right that involves the taking of a life. What difference does that make in your analysis?
Sure, Your Honor. I think it makes a number of differences. One, I'd mention two in particular. One is it really does mark out the unbelievably profound ramifications of this area, which in many other areas, assisted suicide, a whole host of important areas that are important to dignity, autonomy, freedom, and important to matters of conscience. It marks it out as one of the unique areas where this court has taken that important issue to the people, and it's something that implicates life, and it just, I think, marks off, Justice Thomas, how problematic and unusual and how much of a break the court's abortion jurisprudence is from those other cases.
If we don't overrule Casey or Roe, do you have a standard that you propose other than the viability standard?
It would be, Your Honor, a clarified version of the undue burden standard. I would emphasize, I think, as Your Honor is alluding to, that no standard other than the rational basis review that applies to all laws will promote an administrable, workable, practicable, consistent jurisprudence that puts matters back with the people. I think anything heightened here is going to be problematic, but I would say if the court were not inclined to overrule Casey, the choice would be undue burden standard, untethered from any bright line viability rule.
Thank you. Well, if I'd like to go to a different topic, back to Casey.
Yes,
I assume you've read Casey pretty thoroughly.
Yes, Your Honor.
And there are two parts. One is they reaffirm Roe. Put that to the side. The second is an opinion for the court, not for three people, but for the court. And that second part is about what stare decisis principles should be used to overrule a case like Roe. And they say Roe's special. What's special about it? They say it's rare. They call it a watershed. Why? Because the country is divided, because feelings run high, and yet the country, for better or for worse, decided to resolve their differences by this court laying down a constitutional principle, in this case, women's choice. Right? That's what makes it rare. That's not what I'm asking you about. I want your reaction to what they said follows from that. What the court said follows from that is that it should be more unwilling to overrule a prior case. Far more unwilling we should be, whether that case is right or wrong, than the ordinary case. And why? Well, they have a lot of words there, but I'll give you about 10 or 20. There will be inevitable efforts to overturn it. Of course there will. Feelings run high. And it is particularly important to show what we do in overturning a case is grounded in principle and not social pressure, not political pressure. Only, quote, the most convincing justification can show that a later decision overruling, if that's what we did, was anything but a surrender to political pressures or new members. And that is an unjustified repudiation of principles on which the court stakes its authority. And then there are two sentences I'd like to read, because they say they really mean this, the court, not just three. To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. And the last sentence, after they quote Potter Stewart on the same point, they say overruling unnecessarily and under pressure would lead to condemnation, the court's loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Now, that's the opinion of the court. All right? And it's about stare decisis and how we approach it. And I hope everybody reads this. It's at 505 U.S. 854 to 869. All right. What do you say to that?
Sure, Justice Breyer. I would say a couple things. I would say we have very closely gone through the factors that the Casey court itself went through in stare decisis. More than half of our brief is devoted to stare decisis. We now have 30 years in the wake of Casey to see what Casey has done and what it hasn't done.
Well, it's called some bad things in the eyes of some people and some good things in the eyes of some people.
Your Honor.
All right, go ahead.
I'm sorry, Your Honor. What I'd emphasize, Your Honor, is that to the extent that I would not say it was the people that called this court to end the controversy. The people, many people vocally really just wanted to have the matter returned to them so that they could decide it locally, deal with it the way they thought best, and at least have a fighting chance to have their view prevail, which was not given to them under Roe and then as a result under Casey. And I'd also emphasize, Your Honor, that on stare decisis, just as I said, the last 30 years, workability, developments in the law, factual developments that states can't account for, the workability, the undue burden standard alone, many problems. On all the metrics that Casey was describing, or the vast bulk of them, Casey fails. And I'd also emphasize this as well, Justice Breyer, that Casey was not was not a great example of simply letting precedent stand. It recast Roe's reasoning. It overruled two of the court's most important abortion decisions. It jettisoned the trimester framework of Roe itself and adopted a new standard unknown to other parts of the law. Those are not the hallmarks of precedent, and they failed under this court's stare decisis.
Okay, can I take it that your answer is, yes, you accept the way, the special rule, the rule for the rare watershed, the stare decisis principles for deciding whether to overturn such a case as Roe. You accept that, and you think it's met.
I would say yes, in part, Justice Breyer. And here's what I'd emphasize: is that I do think, particularly when Casey looked outward and looked to what it saw as pressure, there were pressure on all sides. As Your Honor noted, this is a hot, difficult issue for everyone. That's why it belongs to the people. And I think the conclusion the court drew from that it couldn't provide a good enough example, that it would look unprincipled, those conclusions were, with respect, Justice Breyer, mistaken. And the last 30 years has not seen any calming of that. It's been very different than some of the court's other controversial decisions that have seen much more calm.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? I don't see how it is possible. It's what Casey talked about when it talked about watershed decisions. Some of them, Brown versus Board of Education, it mentioned, and this one, have such an entrenched set of expectations in our society that this is what the court decided, this is what we will follow, that we won't be able to survive if people believe that everything, including New York versus Sullivan, I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in seeing this as a personal right as opposed to a militia right. If people actually believe that it's all political, how will we survive? How will the court survive?
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well-grounded in the Constitution, in text, structure, history, and tradition, and that carefully goes through the stare decisis factors as we've laid out.
That.
No, it didn't, Your Honor,
Casey went through every one of them. You think it did it wrong. That's your belief. But Casey did that.
Well,
and you haven't added
Your Honor.
much to the discussion in your papers as to the errors that Casey made, other than I disagree with them, Casey.
Justice Sotomayor, maybe I can highlight two. Casey gave one paragraph to the workability of Roe. It then adopted the undue burden standard, which is perhaps the most unworkable standard in American law. It gave about 3 paragraphs, if memory serves, to reliance, which doesn't account for the last 30 years and the changes that have occurred since Casey. It gave a brief factual view to things that have changed since Roe. Those, of course, are not going to take account of the last 30 years of advancements in medicine, science, all of those things.
What are the advancements in medicine?
I think it's an advancement in knowledge and concern about such things as fetal pain, what we know the child is doing and looks like and is fully human from a very early...
In regular cases, courts decide whether science fits the Daubert standard. Obviously, under the Daubert standard, the minority of people, a gross minority of doctors, who believe fetal pain exists before 24, 25 weeks. It's a huge minority, and one not well founded in science at all. So I don't see how that really adds anything to the discussion. That a small fringe of doctors believe that pain could be experienced before a cortex is formed doesn't mean that there's been that much of a difference since Casey.
We pointed out as an example, Your Honor, of where Roe and Casey improperly preclude states from taking account for these things, and they should be able to be concerned about a fact of an unborn life being poked and then recoiling in the way one of us would recoil.
General, I know what it said about viability in Roe, but was viability an issue in the case? I know it wasn't briefed or argued.
It was not an issue certainly the way it is an issue here, Your Honor. I think it was, to the extent that the court had to reaffirm Roe, the way to read that as something other than dicta would be to understand.
I'm sorry, I don't know what that said. Was it an issue in Roe?
Oh, in Roe?
Yeah.
I'm sorry, Your Honor. My understanding is no. I mean, the law there was didn't have a viability tag. That was inserted by.
In fact, if I remember correctly, and it's an unfortunate source, but it's there. In his papers, Justice Blackmun said that the viability line was dicta, and presumably he had some insight on the question.
I think, and I'd add, Your Honor, Justice Blackmun, and I think as well his papers pointed out the arbitrary nature of it and the line drawing problems in there too.
And then in Casey said that was the core principle or the central principle in Roe, viability. It said that after tossing out the trimester formula, which many people thought was the core principle. But was viability at issue in Casey?
I don't think it was squarely at issue, Your Honor. Again, it's a little hard not to take the court at its word when it emphasized that viability is the central part of Roe's holding, and saying that it is reaffirming that. So we kind of take that as it stands, but the court has not. It did not face a law like this, certainly, Mr. Chief Justice.
May I finish my inquiry?
Of course, Justice Sotomayor.
Virtually every state defines a brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness. So I go back to my question of what has changed in science to show that the viability line is not a real line, that a fetus cannot survive. And I think that's what both courts below said, that you had no experts say that there is any viability before 23 to 24 months.
And what I'd say is this, Justice Sotomayor, is that the fundamental problem with viability, it's not really something that rests on science so much. It's that viability is not tethered to anything in the Constitution, in history, or tradition. It's a quintessentially legislative line. A legislature could think that viability makes sense as a place to draw the line, but it's quite reasonable for a legislature to draw the line elsewhere.
There's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison. There is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means. It was totally novel at that time. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. And here in Casey and in Roe, the court said there is inherent in our structure that there are certain personal decisions that belong to individuals and the states can't intrude on them. We've recognized them in terms of the religion parents will teach their children. We've recognized it in their ability to educate at home if they choose. They just have to educate them. We have recognized that sense of privacy in people's choices about whether to use contraception or not. We've recognized it in their right to choose who they're going to marry. I fear none of those things are written in the Constitution. They have all, like Marbury versus Madison, been discerned from the structure of the Constitution. Why do we now say that somehow Roe versus Roe and Casey are so unusual that they must be overturned?
Well, Justice Sotomayor, I would emphasize two things. When you're going beyond the Constitution, this court has looked closely to...
No, what I'm saying is they didn't go beyond the Constitution.
Your Honor, they did not deduce those from the structure of the Constitution. They pointed to the 14th Amendment and reasoned that privacy in Roe, autonomy and similar values in Casey led to a right to abortion. That's not how this court traditionally does things, including in the vast run of cases that Your Honor ran through. The court looks to history and tradition, and here those decisively reject the proposition that states cannot legislate comprehensively on abortion before, after viability, and all throughout. So it's history and tradition, Your Honor. And I would also add, Your Honor, that those decisions, a great many of them draw, not just draw from text, history, and tradition, but they draw often clear lines, very workable, have not led to the many negative stare decisis factors that we identify here.
General, go ahead. Go ahead, Dr. Barrett. Would a decision in your favor call any of the cases, that Justice Sotomayor is identifying into question?
No, Your Honor. I think for a couple reasons. First of all, I think the vast run of those cases, and some mentioned from time to time, I think Griswold, Lawrence, Obergefell, these are cases that draw clear rules. You can't ban contraception, can't ban intimate romantic relationships between consenting adults, can't ban marriage of people of the same sex. Clear rules that have engendered strong reliance interests and that have not produced negative consequences or all the many other negative stare decisis considerations we pointed out, Your Honor. Also, I'd add, none of them involve the purposeful termination of a human life. So those two features, stare decisis and termination of a human life, Your Honor, puts all of those safely out of reach if the court overrules here.
Okay, so I'm sorry to interrupt again, but we really might be making progress. I mean, in the part that I read, of Casey,
yes, Your Honor.
I think they think go back 150 years, maybe now we could go back 200. They think there have only been two cases, which were what they call the watershed, and where these special tough overruling rules apply. You want this to be the third? Or do you think there were more? And if so, what were they?
Well, Your Honor, I think there's quite a bit of difference. I think the question is never, is it bad to overrule, period? Surely starting...
I'm asking you to think in their terms. There were two they mentioned, you say. And they don't want Casey they don't want Roe to be the third. And now, in your opinion, you just answered Justice Barrett, or, hey, all these are not rising to that level. Okay?
Right.
Are there any that do rise to the level, in your opinion?
I think, and I'm not sure that I necessarily agree with the watershed characterization, Your Honor. What I'd say, though, I can't think of another that kind of hits the radar, but I'd emphasize that the problem here is we're dealing with a right that doesn't have a basis in constitutional text, and again, very much in conflict with those values, Justice Breyer.
I'm not sure how your answer makes any sense. All of those other cases, Griswold, Lawrence, Obergefell, they all relied on substantive due process. You're saying there's no substantive due process in the Constitution, so they're just as wrong according to your theater.
No, Your Honor, we're quite comfortable with Washington versus Glucksberg and how it analyzes substantive due process, and it looks to text history, it looks to history and tradition to discipline the inquiry and make sure.
I mean, in Obergefell, there was no history of same-sex marriage.
And I think the court pointed out, look, when we were facing Loving versus Virginia.
I'm not trying to argue that we should overturn those cases. I just think you're dissimulating when you say that any ruling here wouldn't have an effect on those.
Respectfully, that's.
Do you think that no state is going to think otherwise? That no people in the population aren't going to challenge those cases in court?
I mean, Your Honor, we'll always have a diversity of views, but I think
that's the point.
I think that's one of the benefits of our society.
Isn't that the point?
That there's a diversity of views and people can vigorously debate and make decisions
exactly, and that's what we're still doing, and that's what we're doing under undue burden, but we haven't been doing it on the viability line.
And neither one has worked well. The viability line discounts and disregards state interests, and the undue burden standard has all of the problems that
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it? Because it assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor, aside from...
I'm putting it aside from religion.
I'll try to, I think there might be more than one question, and I'll do my very best, Justice Sotomayor. I think this court in Gonzalez pretty clearly recognized that before viability, we are talking with unborn life with a human organism. And I think the philosophical questions Your Honor mentioned, all those reasons that they're hard, they've been debated, they're important, those are all reasons to return this to the people, because the people should get to debate these hard issues. And this court does not in that kind of a circumstance.
So when does the life of a woman and putting her at risk enter the calculus? Meaning, right now, forcing women who are poor, and that's 75% of the population, and much higher percentage of those women in Mississippi who elect abortions before viability, they are put at a tremendously greater risk of medical complications and ending their life, 14 times greater to give birth to a child full term than it is to have an abortion before viability. And now the state is saying to these women, we can choose not only to physically complicate your existence, put you at medical risk, make you poorer by the choice, because we believe what? That
Sure, Your Honor. I think to answer, I think the question I think you led with and then I think it expanded on, but is still on the same issue, is as to when does a woman's interest enter, as far as we're concerned, it's there the entire time. Our point is that all of the interests are there the entire time, and Roe and Casey improperly prevent states from taking account and weighing those interests however they think best. We're not saying—
General, are there secular philosophers and bioethicists who take the position that the rights of personhood begin at conception or at some point other than viability?
I believe so. I mean, I think there's a wide array, I mean, of people of kind of all different views and of no faith views who would reasonably have that view, Your Honor. It's not tied to a religious view, and I don't think, were it otherwise, this court's jurisprudence would, on this issue, would run right into some of its religious exercise jurisprudence.
General, Justice Breyer started with stare decisis, an important principle in any case. And here, for the reasons that Casey mentioned, especially so, to prevent people from thinking that this court is a political institution that will go back and forth depending on what part of the public yells loudest, and preventing people from thinking that the court will go back and forth depending on changes to the court's membership. And what strikes me about this case, and you come here very honestly, saying, you know, we want you to discard the entire setup, and then even if you don't do that, we want you to discard the viability line, which you've acknowledged again today. Casey says is the heart, the central principle of Roe. And so usually there has to be a justification, a strong justification in a case like this, beyond the fact that you think the case is wrong. And I guess what strikes me when I look at this case is that, you know, not much has changed since Roe and Casey, that people think it's right or wrong based on the things that they have always thought it was right and wrong for. So the rationale behind those cases has something to do with the autonomy and the freedom and the dignity of women to pursue their lives as they wish, to protect their bodily integrity, to make the decisions that are most fundamental to the course of their lives. And always in those cases, there was an understanding that there were important interests on the other side in protecting life or protecting the potential for life, whether people saw it one way or the other way, and that there was a difficult question here and a balance to be made. And I mean, it strikes me that some people think those decisions made the right balance, and some people thought they made the wrong balance. But in the end, we are in the same exact place as we were then, except that we're not, because there's been 50 years of water under the bridge, 50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country, and that places us in an entirely different situation than if you had come in 50 years ago and made the same arguments. So I guess I just wanted to hear you react to that.
Of course, Justice Kagan, thank you. I would emphasize a couple things, Your Honor. The fact that so much time has passed, let's say nothing had changed. That's not a point in Roe and Casey's favor. They have no basis in the Constitution. They adopt a right that purposefully leads to the termination of now millions of human lives. If nothing had changed, they'd be just as bad as they were 30 years ago, 50 years ago, and now we just have decades of damage, and we have a situation where nearly 30 years after Casey, the court unfortunately divides over what Casey, the lead case in the abortion area, even means. The lower courts are left not knowing what to do, as I think kind of a fundamental problem here is, I think, as Justice Gorsuch mentioned, emphasized in his opinion in June Medical, that the problem for lower court judges is the Constitution doesn't give them an answer to this. There's no neutral rule of law, so judges unfortunately have to look within themselves, and that's just never going to solve this issue. But if the matters return to the people can deal with it, they can work, they can compromise and reach different solutions. But if we don't do that, we're just going to have all this sort of damage, and at some point it's appropriate for the court to say enough, as it has in some of the great overrulings in Brown and in other cases where it said this is just enough. Justice Harlan had it right in dissent in Plessy when he recognized that all are equal, and similarly here, the state should be able to recognize, hey, there are real values on both sides here. We think that this one slightly outweighs, or we think that there's some balance to be drawn here. But if the court doesn't do that, Justice Kagan, it's just going to be continued damage, and the court will continue to plunge in this political issue. I apologize, Mr. Chief Justice, I've gone over.
No, that's all right. I have just a few little, well, not little, I hope, questions. And the first gets back to the issue of viability. In your petition for cert, your first question, and the only one on which we granted review, was whether all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked a lot more about whether or not Roe and Casey should be overruled. And I wanted to give you a chance to explain that.
Sure, Your Honor. So a couple points. At the petition stage, we were, of course, we'd identified for the court 3 questions. We emphasized, as you do at the cert stage, hey, this is important. Only this court can resolve it. We emphasized, I believe it was 5 times, that the court was at the least going to need to reconsider, revisit, or reevaluate its precedents. And we asked the court to at least get rid of a viability line or any suggestion of a viability line. So we added, however, and we had to take account of the reality that this argument has not fared well in the lower courts. It's lost in every court of appeals. So, we raised the issue in addition, but once the court granted only the first question, we presented every argument as we, signaled we would present the full-blown constitutional merits argument with that fundamental question. So I'd emphasize that, Your Honor. It was kind of the shift you go from cert stage to merit stage. The court granted one question. That question fairly includes what is the correct standard?
Well, it fairly includes the broader arguments you raised. I'm not suggesting that. But on the other hand, it presumably included the viability question as well, because that's what you talked about in that one sentence.
And we've addressed that as well, Your Honor. What I'd emphasize here is that the merits arguments of, the validity of Roe and Casey as an original matter, is there a viability rule based in the Constitution? Those are not that complicated or lengthy. The harder questions are, should the court overrule and take that momentous step? And that's why we devote a lot of space to that very important issue. We respect stare decisis and have walked through all those points, but again, focusing on the question presented and presenting our best arguments for that, that's what we've done, Mr. Chief Justice.
On stare decisis, I think the first issue you look at is whether or not the decision at issue was wrongly decided. I've actually never quite understood how you evaluate that. Is it wrongly decided based on the legal principles and doctrine when it was decided, or in retrospect? Because Roe, there are a lot of cases around the time of Roe, not of that magnitude, but the same type of analysis that went through exactly the sorts of things we today would say were erroneous. But do we look at it from today's? If we look at it from today's perspective, it's going to be a long list of cases that we're going to say were wrongly decided.
Well, I'd say, Mr. Chief Justice, that you can look both. Was it wrong at the time? Has it been unmasked as wrong by new understandings, new knowledge, and any developments? But I don't think, as I think my colloquy with Justice Barrett indicated, the court won't have to be looking at many other areas, because this is an area that has a uniquely problematic set of stare decisis considerations. A lot of other controversial areas, or once controversial areas, are quite settled, clear rules, and don't have those considerations against them. So really, by overruling Roe and Casey, the court won't have to go down that road, and a lot of those decisions are quite readily groundable in history, tradition, and the court's traditional factors, Your Honor.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Kay? Justice?
I just wanted to get your quick sense of how your intermediate positions would work. if basically the viability line was discarded and undue burden became the standard overall, a standard that, according to you, is an unclear one, what that would leave the court with going forward. I'm just sort of thinking about the great variety of regulations that states could pass. So whether one is 15 weeks and one is 12 weeks and one is 9 weeks, or variation across a wide variety of other dimensions, what would that look like coming to the court? How do you think we would be able to deal with that, or how would you counsel us to deal with that if the court were to go down that road?
Well, I think this is not to push back against the end, and I will answer your question, Justice Kagan, but part of why we've counseled to overrule full scale is that that's the only way to get rid of a number of the problems that I think Your Honor is alluding to. And that's that when you have the undue burden standard, it's a very hard standard to apply. It's not objective. The court looks to the record in each case and what's going on. I mean, the court in Casey itself said under this record, this is not an undue burden. You couldn't say necessarily for certain that a certain number of weeks one place would be an undue burden, but would be okay another place. But again, that is the world we have under Casey. So if the court upholds this law under the undue burden standard, it would be carrying forward those features, which and I hope I've answered your question, but I think that's one of the very strong reasons to just go all the way and overrule Roe and Casey, Your Honor. Anyway.
Justice Gorsuch? Justice Kavanaugh?
I want to be clear about what you're arguing and not arguing. Yes. And to be clear, you're not arguing that the court somehow has the authority to itself prohibit abortion, or that this court has the authority to order the states to prohibit abortion, as I understand it, correct?
Correct, Your Honor.
And as I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process. Is that accurate?
Right. We're saying it's left to the people, Your Honor.
And so for if you were to prevail, the states, majority of states, or states still could and presumably would continue to freely allow abortion. Many states, some states, would be able to do that even if you prevail under your view. Is that correct?
That's consistent with our view, Your Honor. It's one that allows all interests to have full voice, and many of the abortions we see in certain states that I don't think anybody would think would be moving to change their laws in a more restrictive direction.
Thank you.
Thank you, Your Honor.
Justice Barrett?
General, I have a question that is a little bit of a follow-up to one that Justice Breyer was asking you. That's about stare decisis, and I think a lot of the colloquy you've had with all of us has been about the benefits of stare decisis, which I don't think anyone disputes. And of course, no one can dispute, because it's part of our stare decisis doctrine, that it's not an inexorable command and that there are some circumstances in which overruling is possible. We have Plessy, Brown, we have Bowers versus Hardwick to Lawrence. But in thinking about stare decisis, which is obviously the core of this case, how should we be thinking about it? I mean, Justice Breyer pointed out that in Casey, and in some respects, well, it was a different conception of stare decisis insofar as it very explicitly took into account public reaction. Is that a factor that you accept? Or are you arguing that we should minimize that factor? And is there a different set of rules? It is true that Casey identified Brown and West Coast Hotel as watershed decisions, but is there a distinct set of stare decisis considerations applicable to what the court might decide as a watershed decision?
I don't think there should be a distinct set of considerations there, Your Honor. I think what I emphasize, and just to make sure, on the kind of legitimacy, the court looking outward, I think Casey was unusual in that regard. I think it was a mistake, and I think it's something that is kind of in conflict with this court's structure and approach as an independent branch, looking to the Constitution rather than looking without. And I think that's one reason why traditionally the court is in some of its greatest overrulings, it's not looking without. It's saying this was wrong. It was wrong the day it was decided. We know it's wrong today, and it's led to all these terrible consequences. We should get rid of it. So I think that was an unfortunate break, and I think the court, even if the court were to still look at legitimacy, though, Justice Barrett, I think the court could very, very powerfully say, look, our legitimacy really derives from our willingness to stand strong and stand firm in the face of whatever is going on, and stand for constitutional principle and follow our traditional stare decisis factors to overrule when it's appropriate. Thank you, Your Honor.
Thank you, counsel.
Thank you, Mr. Chief Justice.
Ms. Rickleman?
Mr. Chief Justice, and may it please the court, Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades of precedent. Mississippi asks the court to dismantle this precedent and allow states to force women to remain pregnant and give birth against their will. The court should refuse to do so for at least 3 reasons. First, stare decisis presents an especially high bar here. In Casey, this court carefully examined and rejected every possible reason for overruling Roe, holding that a woman's right to end a pregnancy before viability was a rule of law and a component of liberty it could not renounce. The question then is not whether Roe should be overturned, but whether Casey was egregiously wrong to adhere to Roe's central holding. Second, Casey and Roe were correct. For a state to take control of a woman's body and demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty. Preserving a woman's right to make this decision until viability protects her liberty while logically balancing the other interests at stake. Third, eliminating or reducing the right to abortion will propel women backwards. 2 generations have now relied on this right, and 1 out of every 4 women makes the decision to end a pregnancy. Mississippi's ban would particularly hurt women with a major health or life change during the course of a pregnancy, poor women who are twice as likely to be delayed in accessing care, and young people or those on contraception who take longer to recognize a pregnancy. To avoid profound damage to women's liberty, equality, and the rule of law, the court should affirm.
Counsel, I just have one question. I assume you, from your brief, you're relying on an autonomy theory.
Both bodily integrity and the ability to make decisions related to family, marriage, and childbearing, Your Honor.
Shortly, some years after we decided Casey, we had a case out of South Carolina, I believe, involved a woman who had been convicted of criminal child neglect because she ingested cocaine during pregnancy. In her case was post-viability, so it doesn't fit in the facts of this case. If she had ingested cocaine pre-viability and had the same negative consequences to her child, do you think the state had an interest in enforcing that law against her?
The state may have, Your Honor. The state can certainly regulate to serve its interests in fetal life and in women's health. Those particular laws tend to undermine both of those interests because they deter women from seeking prenatal care, which is counterproductive to both their health.
But the pre-viability as well as post-viability?
No, Your Honor. The court has been clear that after viability, states can prohibit abortion except to save a woman's life.
No, I mean in my example of criminal child neglect. I understand your argument is about abortion. I am trying to look at the issue of bodily autonomy and whether or not she has a right also to bodily autonomy in the case of ingesting an illegal substance and causing harm to a pre-viability fetus.
Your Honor, of course, those issues aren't posed in this case. And again, I would say that the states can certainly regulate throughout pregnancy, both before and after viability, to preserve fetal life and to preserve the woman's health. The court has said, however, there are other constitutional issues at stake, for instance, in the Ferguson case, that states still can't violate women's Fourth Amendment rights. But again, that's not what this case is about. This case is about a ban on abortion that the state concedes is weeks before viability, and the court has been clear for 50 years that the one thing that states cannot do is to take the decision completely away from the woman until viability. That until that point, it is her decision to make, given the unique physical demands of pregnancy and the life-altering consequences of pregnancy and having a child.
Thank you. The point you made about the impact on women and their place in society, those were certainly made in Roe as well. What we have before us, though, is a 15-week standard. Are you suggesting that the difference between 15 weeks and viability are going to have the same sort of impacts as you were talking about, or as we were talking about in Roe?
Yes, Your Honor, I believe they would, because people who need abortion after 15 weeks are often in the most challenging circumstances. As I mentioned, there are people who have perhaps had a major health or life change, a family illness, a job loss, a separation, young people or people who are on contraception or pregnant for the first time and who are delayed in recognizing the signs of pregnancy, or poor women who often have much more trouble navigating access to care. And if they're denied the ability to make this decision because there's a ban after 15 weeks, they will suffer all of the consequences that the court has talked about in the past. And in fact, the data has been very clear over the last 50 years that abortion has been critical to women's equal participation in society. It's been critical to their health, to their lives, their ability to pursue.
I'm sorry, what kind of data is that?
I would refer the court to the brief of The Economist in this case, Your Honor, and it compiles data showing studies based actually on causal inference, showing that it's the legalization of abortion and not other changes that have had these benefits for women in society. And again, those benefits are clear for education, for the ability to pursue a profession, for the ability to have...
Well, putting that data aside, if you think that the issue is one of choice, that women should have a choice to terminate their pregnancy, that supposes that there is a point at which they've had the fair choice, opportunity to choice. And why would 15 weeks be an inappropriate line? So viability, it seems to me, doesn't have anything to do with choice. But if it really is an issue about choice, why is 15 weeks not enough time?
For a few reasons, Your Honor. First, the state has conceded that some women will not be able to obtain an abortion before 15 weeks, and this law will bar them from doing so. And a reasonable possibility standard would be completely unworkable for the courts. It would be both less principled and less workable than viability, and some of the reasons for that are, without viability, there will be no stopping point. States will rush to ban abortion at virtually any point in pregnancy. Mississippi itself has a 6-week ban that it's defending with very similar arguments as it's using to defend the 15-week ban, and there are states that have bans.
Well, I know, but I'd like to focus on the 15-week ban because that's not a dramatic departure from viability. It is the standard that the vast majority of other countries have. When you get to the viability standard, we share that standard with the People's Republic of China and North Korea. And I don't think you have to be in favor of looking to international law to set our constitutional standards to be concerned if those are share that particular time period.
I think there's two questions there, Your Honor, if I may. First, that is not correct about international law. In fact, the majority of countries that permit legal access to abortion allow access right up until viability, even if they have nominal lines earlier. So, for example, Canada, Great Britain, and most of Europe allows access to abortion right up until viability, and it also doesn't have the same barriers in place.
What do you mean, even if they have nominal lines earlier?
Some countries, Your Honor, have a nominal line of 12 weeks or 18 weeks, but they permit legal access to abortion after that point for broad social reasons, health reasons, socioeconomic reasons. So their regimes really aren't comparable, and they also don't have the same types of barriers that we have here. So if the court were to move the line substantially backwards, and 15 weeks is 9 weeks before viability, Your Honor, it's quite a bit backwards, it may need to reconsider the rules around regulations, because if it's cutting the time period to obtain an abortion roughly in half, then those barriers are going to be much more important.
Thank you.
Ms. Rickelman, I have a question about the safe haven laws. So petitioner points out that in all 50 states, you can terminate parental rights by relinquishing a child after abortion, and I think the shortest period might have been 48 hours, if I'm remembering the data correctly. So it seems to me, seen in that light, both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities. It's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to follow that pregnancy and then parenthood are all part of the same burden. And so it seems to me that the choice more focused would be between, say, the ability to get an abortion at 23 weeks or the state requiring the woman to go 15, 16 weeks more and then terminate parental rights at the conclusion. Why didn't you address the safe haven laws, and why don't they matter?
I think they don't matter for a couple of reasons, Your Honor. First, even if some of those laws are new since Casey, the idea that a woman could place a child up for adoption has, of course, been true since Roe. So it's a consideration that the court already had before it when it decided those cases and adhered to the viability line. But in addition, we don't just focus on the burdens of parenting, and neither did Roe and Casey. Instead, pregnancy itself is unique. It imposes unique physical demands and risk on women, and in fact has impact on all of their lives, on their ability to care for other children, other family members, on their ability to work. And in particular, in Mississippi, those risks are alarmingly high. It's 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion, and those risks are disproportionately threatening the lives of women of color.
So are you saying, I mean, actually, as I read Roe and Casey, they don't talk very much about adoption. It's a passing reference that means out of the obligations of parenthood. But as I hear this answer, then are you saying that the right, as you conceive of it, is grounded primarily in the bearing of the child, in the carrying of pregnancy, and not so much looking forward into the consequences on professional opportunities and work life and economic burdens?
No, Your Honor, I believe it's both, and that is exactly how Casey talked about it. It talked about the two strands of cases that supported the right. One was the strand of cases supporting bodily integrity, and it cited to cases like Cruzan and Riggins versus Nevada. And the second was the strand of cases supporting decisional autonomy, and specifically decisions related to childbearing, marriage, and procreation decisions like Griswold, Loving. And so it's really both strands that we're relying on here.
May I ask you a question about stare decisis, counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's trimester framework and replaced it with an undue burden standard. They argue that the undue burden standard was not well known to the law before that. And then they argue that the undue burden standard has evolved over time, too, in ways that the court has found difficult to agree upon. In Hellerstedt, for example, they point out in their briefs that the court seemed to suggest that a court should consider both the benefits and the burdens associated with the proposed restriction. In June Medical, more recently, the court splintered on that same question, whether benefits could be considered or only burdens. And so the argument goes that this has proved to be putting aside all the other obviously difficult questions in the case, that the standard itself has proved difficult to administer, and that is relevant to the stare decisis analysis. And I just wanted to give you an opportunity to respond.
Yes, Your Honor. The first point I'd like to make is the undue burden test is not at issue in this case. That is the test that applies to regulations, not prohibitions, and the state has conceded that this is a prohibition. In fact, that's the title of this law, is an act to prohibit abortion after 15 weeks. And the only thing that's at issue in this case is the viability line, and the viability line has been enduringly workable. The lower federal courts have applied it consistently and uniformly for 50 years, and the Fifth Circuit here below had no difficulty striking down this law unanimously 3-0. So it's been an exceedingly workable standard. And if I may return to your question, Mr. Chief Justice, a reasonable possibility standard would not be workable. It would ultimately boil down to an argument that states can prohibit a category of women from exercising a constitutional right merely because of the number of people in the category, and that's just not how constitutional rights work. A state would never say that it could ban religious services on a Wednesday evening, for example, simply because most people could attend religious services on another night of the week.
So I actually just wanted to, that's helpful, I think. I just want to make sure I understand what you're telling me, counsel, that if the court were to, in this case, step past viability and apply undue burden, the undue burden test to regulations prior to viability, you would agree with the other side, I think, that that's not a workable standard. Is that a fair understanding of what you're telling the court?
No, Your Honor. I believe
think that would be workable?
I believe that, if I may clarify, I believe the undue burden test has been workable for regulations. That
I understand that. If it were to apply, if the court were to, and I thought this is what you were saying in response to the Chief Justice, but maybe I'm mistaken. Please correct me if I am, but what is your argument against applying the undue burden standard prior to viability?
If the undue burden standard, as this court laid out in Casey, which includes the viability line, is applied.
I'm asking, I know we're fighting the hypothetical here, counsel, all right? Accept the hypothetical. Hypothetically, the court were to extend the undue burden standard to regulations prior to viability. Would that be workable, or would that not be workable in your view?
Without viability, it would not be workable, Your Honor, because it would ultimately, again, always come down to a claim that states can bar a certain category of people from exercising this right simply because of the number of people in the category. And that's not a workable standard, and it's not a constitutional.
I appreciate that clarification. Thank you.
Just to follow up on that, I read your brief to say that the only real options we have are to reaffirm Roe and Casey as they stand, or to overrule them in their entirety. You say that, quote, there are no half measures here. Is that a correct understanding of your brief?
Your Honor, it's certainly the arguments that the state has presented is what we're responding to there, which is that all of the state's arguments, including their alternatives, which are undue burden without viability, would be the equivalent of overruling Casey and Roe, because the viability line is the central holding of those cases. Casey mentioned it no fewer than 19 times, and the court in June Medical just a year ago affirmed that the viability line is the central holding of both Casey and Roe.
Well, you do emphasize that the court drew the line at viability in Roe and reaffirmed that in Casey, and that is certainly something that we have to take very seriously into consideration. But suppose we were considering that question now for the first time. I'm sure you know the arguments about the viability line as well as I do, probably better than I do. What would you say in defense of that line? What would you say to the argument that has been made many times by people who are pro-choice and pro-life that the line really doesn't make any sense, that it is, as Justice Blackmun himself described it, arbitrary? If a woman wants to be free of the burdens of pregnancy, that interest does not disappear the moment the viability line is crossed. Isn't that right?
No, Your Honor, and if I may make a few points to answer your question. First, I think the state views viability as arbitrary because it completely discounts the woman's interest. But viability—
But does a woman have, upon reaching the point of viability, does not the woman have the same interest that she had before viability in being free of this pregnancy that she no longer wants to continue?
Viability is a principled line, Your Honor, because in ordering the
I'm
interest...
trying to see whether it is a principled line.
Yes,
you agree with me, at least on that point, that a woman still has the same interest in terminating her pregnancy after the viability line has been crossed?
Yes, Your Honor, but the court balanced the interest, and in ordering the interest
look
at
the
stake...
interest on the other side. The fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability?
In some people's view, it doesn't, Your Honor, but what the court said is that those philosophical differences couldn't be resolved in a way...
That's what I'm getting at. What is the philosophical argument, the secular philosophical argument for saying this is the appropriate line? There are those who say that the rights of personhood should be considered to have taken hold at a point when the fetus acquires certain independent characteristics. But viability is dependent on medical technology and medical practice. It has changed. It may continue to change.
No, Your Honor, it is principled because in ordering the interest at stake, the court had to set a line between conception and birth, and it logically looked at the fetus's ability to survive separately as a legal line because it's objectively verifiable and doesn't require the court to resolve the philosophical issues at stake.
I just want to focus on stare decisis for a little bit. I found my colleague, Justice Breyer's comments quite compelling. I'm not quite sure how they play out in Casey. It is certainly true that we cannot base our decisions on whether they're popular or not with the people. Casey seemed to say we shouldn't base our decisions not only on that, but whether they're going to seem popular. And it seemed to me to have a paradoxical conclusion that the more unpopular the decisions are, the firmer the court should be in not departing from prior precedent. It's sort of a super stare decisis, but it's super stare decisis for what are regarded as, by many, as the most erroneous decisions. Do you think there is that category, or is it just normal stare decisis?
I think it is precedent on precedent, Your Honor, because Casey did the stare decisis analysis for Roe. So the question before this court is whether that stare decisis analysis was egregiously wrong. And if I may answer your earlier question about whether viability was squarely at issue in Casey, it clearly was, Your Honor. At pages 869 to 871, the court squarely addressed viability because the government had made the argument that viability was arbitrary.
I appreciate that Casey addressed it, but that's different than saying it was at issue. It said it was the central principle of Roe because it was pretty much all that was left after they were done dealing with the rest of it. And the regulations in Casey had no applicability or not depending upon where viability was. They applied throughout the whole range, period. So if they didn't say anything about viability, it's like what Justice Blackmun said when discussing among his colleagues, which is a good reason not to have papers out that early, is that they don't have to address the line drawing at all in Roe. And they didn't have to address the line drawing at all in Casey.
I disagree with that, Your Honor, because the undue burden test incorporates the viability line. That was what the court was assessing the regulations against, whether they imposed a substantial obstacle in the path of a woman before viability. And if a prohibition like this law isn't a substantial obstacle, then nothing would be. So the issue was squarely before the court, and in fact, the court said at page 879 that in adopting the undue burden test, it was not disturbing the viability line.
It's a very interesting question that I think Justice Barrett raised, too. It's usually just philosophical, but I think it has bite here. When I read Casey, it's not just one-on-one. You know, 2 is greater than 1. Yeah, Casey plus Roe is greater than. They're making a point that we're an institution perhaps more than a court of appeals or a district court. It's Hamilton's point: no purse, no sword, and yet we have to have public support. And that comes primarily, says Casey, I wonder if it was O'Connor who wrote that. I don't know. But it comes primarily from people believing that we do our job, we use reason, we don't look to just what's popular, and that's where you're seeing the paradox. But the problem with the super case, of which we've heard 3 mentioned, the problem with the super case like this, the rare case, the watershed case, where people are really opposed on both sides, and they really fight each other, is they're going to be ready to say, no, you're just political, you're just politicians. And that's what kills us as an American institution. That's what they're saying. So we're looking at it for that, but we are looking to, and that, they say, is a reason why. A reason why, when you get a case like that, you better be damn sure that the normal stare considerations, stare decisis overruling are really there in spades, double, triple, quadruple, and then they go through and show they're not. Okay? What's the paradox? Maybe you think I've just made an argument that there isn't one, but really, in my head, I'm thinking I'm not sure. There may be one. And I don't know if you've ever thought about this. I don't know if you've ever, when that occurred to you, I don't want to overrule the stare. I wouldn't want the court to overrule the stare decisis section of Casey. You say? And that's what I think is being brought up. And maybe I haven't made it clearer, but I've tried to.
Yes, Your Honor. I think the point that the court was making was that the fact that some states may continue to enact laws in the teeth of the court's precedent has never been enough of a reason to overrule. And that's true for a number of decisions that the court has issued. The fact that some people continue to disagree with them is not a basis to discard that precedent.
Justice Thomas, anything further?
Back to my original question. If I know your interest here is in abortion. I understand that. But if I were to ask you what constitutional right protects the right to abortion, is it privacy? Is it autonomy? What would it be?
It's liberty, Your Honor. It's the textual protection in the 14th Amendment that a state can't deprive a person of liberty without due process of law. And the court has interpreted liberty to include the right to make family decisions and the right to physical autonomy, including the right to end a pre-viability pregnancy.
So it's all of the above.
Well, that's how the court has interpreted the Liberty Clause for over 100 years in cases going back to Meyer, Griswold, Carey, Loving, Lawrence.
Yeah, but I mean, all of those sort of just come out of Lochner. So it's we've dropped part of it. So I understand what you're saying, but what I'm trying to focus on is to lower the level of generality, or at least be a little bit more specific. In the old days, we used to say it was a right to privacy that the court found in the due process, substantive due process clause. Okay. So, or in substantive due process. And I'm trying to get you to tell me, what are we relying on now? Is it privacy? Is it autonomy? What is it?
I think it continues to be liberty, and the right exists whatever level of generality the court applies. There was a tradition under the common law for centuries of women being able to end their pregnancies. But in addition, when it comes to decisions related to family, marriage, and childbearing, the court has done the analysis at a higher level of generality, and that makes sense because otherwise the Constitution would reinforce the historical discrimination against women.
Thank you. Justice Breyer? Justice Alito?
Well, you just mentioned the common law, so let me ask you a couple of questions about history. Did any state constitutional provision recognize that abortion was a right, liberty, or immunity in 1868 when the 14th Amendment was adopted?
No, Your Honor, but it had been allowed under the common law for many years.
Does any judicial decision at that time or shortly or immediately after 1868 recognize that abortion was a right, liberty, or immunity?
There were state high court decisions shortly before then, Your Honor, talking about the ability of women to end a pregnancy before quickening.
What's your best case?
For the right to end a pregnancy, Your Honor? Allowing a state to take control of a woman's body and force her to undergo the physical demands, risks, and life-altering consequences of pregnancy is a fundamental deprivation of her liberty. And once the court recognizes that that liberty interest deserves heightened protection, it does need to draw a workable line, and viability is a line that logically balances the interests at stake.
The brief for the American Historical Association says that abortion was not legal before quickening in 26 out of 37 states at the time when the 14th Amendment was adopted. Is that correct?
That is correct, because some of the states had started to discard the common law at that point because of a discriminatory view that a woman's proper role was as a wife and mother, a view that the Constitution now rejects, and that's why it's appropriate to do the historical analysis at a higher level of generality.
In the face of that, can it be said that the right to abortion is deeply rooted in the history and traditions of the American people?
Yes, it can, Your Honor. Again, at the founding, women were able to end their pregnancy under the common law. And in fact, this court in Glucksburg specifically discussed Casey as a decision based on history and tradition. And at note 19 specifically called out and relied on Roe's conclusion that at the time of the founding and well into the 1800s, women had the ability to end a pregnancy.
What was the principal source that the court relied on in Roe for its historical analysis? Who was the author of that article?
I apologize, Your Honor, I don't remember the author. I know that the court spent many pages of the opinion doing a historical analysis. There's also a brief on behalf of several key American historian associations that go through that history in detail, because there's even more information now that supports Roe's legal conclusions.
All right, thank you.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion, and they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue, rather than continuing to pick sides on that issue. So I think that's, at a big picture level, their argument. I want to give you a chance to respond to that.
Yes, a few points, if I may, Your Honor. First, of course, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreements can't be resolved in a way that a woman has no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty. The court has interpreted that liberty to include the ability to make decisions related to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor, and if they're not able to make this decision, if states can take control of women's bodies and force them to endure months of pregnancy and childbirth, then they will never have equal status under the Constitution.
And I want to ask a question about stare decisis and to think about how to approach that here, because there have been lots of questions picking up on Justice Barrett's questions and others. And history helps. Think about stare decisis as I've looked at it, and the history of how the courts applied stare decisis. And when you really dig into it, history tells a somewhat different story, I think, than is sometimes assumed. If you think about some of the most important cases, the most consequential cases in this court's history, there's a string of them where the cases overruled precedent. Brown v. Board outlawed separate but equal. Baker versus Carr, which set the stage for one person, one vote. West Coast Hotel, which recognized the state's authority to regulate business. Miranda versus Arizona, which required police to give warnings when about the right to remain silent and to have an attorney present to suspects in criminal custody. Lawrence v. Texas, which said that the state may not prohibit same-sex conduct. Knapp versus Ohio, which held that the exclusionary rule applies to state criminal prosecutions to exclude evidence obtained in violation of the Fourth Amendment. Gideon versus Wainwright, which guaranteed the right to counsel in criminal cases. Obergefell, which recognized a constitutional right to same-sex marriage. In each of those cases, and that's a list, and I could go on, and those are some of the most consequential and important in the court's history, the court overruled precedent. And it turns out if the court in those cases had listened and they were presented with arguments in those cases, adhere to precedent. In Brown v. Board, adhere to Plessy. In West Coast Hotel, adhere to Atkins and adhere to Lochner. And if the court had done that in those cases, the country would be a much different place. So I assume you agree with most, if not all, the cases I listed there where the court overruled precedent. So the question on stare decisis is why, and I know you disagree with what I'm about to say in the if we think that the prior precedents are seriously wrong, why then doesn't the history of this court's practice with respect to those cases tell us that the right answer is actually to return to the position of neutrality and not stick with those precedents in the same way that all those other cases didn't?
Because the view that a previous precedent is wrong, Your Honor, has never been enough for this court to overrule, and it certainly shouldn't be enough here when there's 50 years of precedent. Instead, the court has required something else, a special justification, and the state doesn't come forward with any special justification. It makes the same exact arguments the court already considered and rejected in its stare decisis analysis in Casey, and in fact, there is nothing different. There is no less need today than 30 years ago or 50 years ago for women to be able to make this fundamental decision for themselves about their bodies, lives, and health.
Thank you.
Justice Barrett?
I want to ask you a follow-up question. The Chief was asking about the viability line and if that was the right place, if that's the right line to draw. So let's take it out of the question of stare decisis and imagine that there's a state constitution that's identical to the 14th Amendment's due process clause. And a state Supreme Court has to decide as a matter of state constitutional law what the scope of an abortion right is. And the second trimester ends at 27 weeks. And so that state Supreme Court says, we think that the right exists, in an absolute sense that the state cannot take away the right up to 27 weeks. And then after that adopts an undue burden standard. As a matter of first principles, is that line acceptable as a matter of constitutional law?
Your Honor, it may be, but I think that the question in this case is whether a line is obviously more principled or obviously more workable than viability because of the stare decisis context.
That's the Roe framework, basically the trimester. Why wouldn't that be workable if you pick a line and say the end of the second trimester, 27 weeks, third trimester, state's interests increase? I don't understand why 27 weeks is less workable than 24.
I'm not trying to suggest it is, Your Honor. And what I was trying to suggest is that the viability line is a principled and workable line. So to change it, there would have to be a new line that's obviously more principled and more workable. And the line that the court has drawn actually...
But that's stare decisis. I'm asking as a matter of first principles.
As a matter of first principle, the viability line makes sense because if the state constitution is the same...
As a matter of prudential judgment. It's not constitutionally required as a matter of first principles because, in fact, we could decide to be more protective and say 27 weeks end of the second trimester.
You could, Your Honor, but the viability line makes sense given the protection for liberty because it comes from the woman's liberty interest in resisting state control of her body. And once the court recognizes that interest, it does need to draw a line, as it does in many other constitutional contexts like the Fourth and Fifth Amendment. And the viability line, as I mentioned, makes sense because it focuses on the fetus's ability to survive separately, which is an appropriate legal line because it's objectively verifiable and doesn't delve into philosophical questions about when life begins.
Thank you, counsel. General Prelogger.
Mr. Chief Justice, and may it please the court. For a half century, this court has correctly recognized that the Constitution protects a woman's fundamental right to decide whether to end a pregnancy before viability. That guarantee that the state cannot force a woman to carry a pregnancy to term and give birth has engendered substantial individual and societal reliance. The real-world effects of overruling Roe and Casey would be severe and swift. Nearly half of the states already have or are expected to enact bans on abortion at all stages of pregnancy, many without exceptions for rape or incest. Women who are unable to travel hundreds of miles to gain access to legal abortion will be required to continue with their pregnancies and give birth with profound effects on their bodies, their health, and the course of their lives. If this court renounces the liberty interest recognized in Roe and reaffirmed in Casey, it would be an unprecedented contraction of individual rights and a stark departure from principles of stare decisis. The court has never revoked a right that is so fundamental to so many Americans and so central to their ability to participate fully and equally in society. The court should not overrule this central component of women's liberty.
General, would you specifically tell me, state what the right is? Is it specifically abortion? Is it liberty? Is it autonomy? Is it privacy?
The right is grounded in the liberty component of the 14th Amendment, Justice Thomas, but I think that it promotes interests in autonomy, bodily integrity, liberty, and equality. And I do think that it is specifically the right to abortion here, the right of a woman to be able to control without the state forcing her to continue a pregnancy, whether to carry that baby to term.
I understand we're talking about abortion here, but what is confusing is that if we were talking about the Second Amendment, I know exactly what we're talking about. If we're talking about the Fourth Amendment, I know what we're talking about because it's written, it's there. What specifically is the right here that we're talking about?
Well, Justice Thomas, I think that the court in those other contexts with respect to those other amendments has had to articulate what the text means in the bounds of the constitutional guarantees. And it's done so through a variety of different tests that implement First Amendment rights, Second Amendment rights, Fourth Amendment rights. So I don't think that there is anything unprecedented or anomalous about the right that the court articulated in Roe and Casey and the way that it implemented that right by defining the scope of the liberty interest by reference to viability and providing that that is the moment when the balance of interest tips and when the state can act to prohibit a woman from getting an abortion based on its interest in protecting the fetal life at that point.
So the right specifically is abortion?
It's the right of a woman prior to viability to control whether to continue with a pregnancy, yes.
Thank you.
General, I am interested in Justice Kavanaugh's long litany of cases in which we've overruled precedent, and we have. Yet you did call this unprecedented. As I see the structure of the Constitution, the body of it is the relationship of the three branches of government, and then there is the relationship of the federal government to the state, and through our incorporation of the 14th Amendment of the state vis-a-vis the individual, it's the federal government and the state's relationship to individuals. And I see the Bill of Rights, including the 14th Amendment, as basically setting the limits, giving individual freedom to do certain things and stopping the government from intruding in those liberties, in those Bill of Rights, correct? Of all of the decisions that Justice Kavanaugh listed, all of them virtually except for maybe one, involved us recognizing and overturning state control over issues that we said belong to individuals. The right in Miranda to be warned was an individual right, correct?
That's right, Justice Sotomayor, and I think that that is a key distinction with the list of precedents that Justice Kavanaugh was relying on. I think that there are really two key distinctions, and the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. And I think that matters because it goes straight to reliance interests. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty. And I think that that would come at tremendous cost to the reliance that women have placed on this right and on societal reliance and what this right has meant for further ensuring
reliance
equality.
Point is a good point, and this may be my fault. I'm talking about pages 854 to 863 in the Casey case, and I've already used up too much time. I can't read those pages out loud. But they do not include the list that Justice Kavanaugh had. They do include two. One is Brown, and the second one is West Coast Hotel versus Parrish. And you could add the gay rights cases as a third, which would fit the criteria. But there are complex criteria that she's talking about that link to the position in the rule of law of this court. So all I would say is you have to read them before beginning to say whether they are overruling or not overruling in the sense meant there, calling for special concern. Now, they say in those, maybe I'd mention too. Wait a minute. Of course, Plessy was wrong when decided, but just a minute. Also remember, Plessy said that separate but equal was a badge of inferiority. No, they said it isn't. Well, all you have to do is open your eyes and look at the South, my friend, and you will see whether it was or it wasn't in 1954. And they made a similar point. They said, are you going to sit here in the middle of the Depression and tell me that Lochner, with its other cases, and pure, just about pure laissez-faire, that we can run the country that way? I mention that because I want people to read those 15 pages with care. And that's why I said that. If you had anything to add to my plea to read it, please do.
Well, Justice Breyer, I agree completely. I have read those pages and reread them many times, and I think that this is actually another key distinction from the cases that Justice Kavanaugh was referring to, and that is, as I understand those passages in Casey, the court carefully walked through each and every stare decisis factor that this court focuses on. It looked at workability of the viability rule, doctrinal underpinnings, legal and factual developments, and critically reliance interests. And down the line, it found that the case for reaffirming Roe was overwhelming. And in that situation, when every factor that the court consults to determine whether to retain precedent counsels in favor of retaining it, I think Casey properly perceived that a decision to overrule nevertheless, perhaps based on a conclusion that the justices thought the case was wrongly decided in the first instance, would run counter to the ability of stare decisis to function as a cornerstone of the rule of law in this context.
Is it your argument that a case can never be overruled simply because it was egregiously wrong?
I think that at the very least, the state would have to come forward with some kind of materially changed circumstance or some kind of materially new argument, and Mississippi hasn't done so in this
really?
case.
So suppose Plessy versus Ferguson was re-argued in 1897, so nothing had changed. Would it not be sufficient to say that was an egregiously wrong decision on the day it was handed down, and now it should be overruled?
It certainly was egregiously wrong on the day that it was handed down, Plessy, but what the court said in analyzing Plessy to Brown and Casey was that what had become clear is that the factual premise that underlay the decision, this idea that segregation didn't create a badge of inferiority, had been entirely mistaken.
So
and here the state
is it your answer that we needed all the experience from 1896 to 1954 to realize that Plessy was wrongly decided? Would you answer my question? Had it come before the court in 1897, should it have been overruled or not?
I think it should have been overruled, but I think that the factual premise was wrong in the moment it was decided, and the court realized that and clarified that when it overruled.
So there are circumstances in which a decision may be overruled, properly overruled, when it must be overruled, simply because it was egregiously wrong at the moment it was decided.
Well, I think every other stare decisis factor likewise would have justified overruling in that interest, that actually it would run counter to any notion of reasonable reliance, that it was not a workable rule, that it had become an outlier in our understanding of fundamental freedoms.
Well, there was a lot of reliance on Plessy. The South built up a whole society based on the idea of white supremacy. So there was a lot of reliance. It was improper reliance. It was reliance on an egregiously wrong understanding of what equal protection means. But your answer is, I still don't understand. I still don't have your answer clearly. Can a decision be overruled simply because it was erroneously wrong, even if nothing has changed between the time of that decision and the time when the court is called upon to consider whether it should be overruled? Yes or no? Can you give me a yes or no answer on that?
This court, no, has never overruled in that situation just based on a conclusion that the decision was wrong. It has always applied the stare decisis factors and likewise found that they warrant overruling in that instance. And Casey did that. It applied the stare decisis factors. If stare decisis is to mean anything, it has to mean that that kind of extensive consideration of all of the same arguments for whether to retain or discard a precedent itself is an additional layer of precedent that needs to be relied on and can form a stable foundation of the rule of law.
General, you've talked a number of times about the reliance interests here, and I think I'd like you to say a little bit more about that, because, sometimes when we talk about reliance interests, it's like there's a rule of law, and you look at it and you say, oh, somebody will enforce my contract because of this rule, and it has a very kind of grounded quality to it. And as Casey talked about the reliance interests here, they're a little bit more airy. And I just wanted to get your sense of what are the reliance interests here, and how do they cash out on the ground?
Well, there are multiple reliance interests here, as I think Casey correctly recognized. Casey pointed to the individual reliance of women and their partners who had been able to organize their lives and make important life decisions against the backdrop of having control over this incredibly consequential decision whether to have a child. And people make decisions in reliance on having that kind of reproductive control, decisions about where to live, what relationships to enter into, what investments to make in their jobs and careers. And so I think on a very individual level, there has been profound reliance. And it's certainly the case that not every woman in America has needed to exercise this right or has wanted to, but 1 in 4 American women have had an abortion. And for those women, the right secured by Roe and Casey has been critical in ensuring that they can control their bodies and control their lives. And then I think there's a second dimension to it that Casey also properly recognized, and that's the societal dimension. That's the understanding of our society, even though this has been a controversial decision, that this is a liberty interest of women. It's the case that not everyone agrees with Roe versus Wade, but just about every person in America knows what this court held. They know how the court has defined this concept of liberty for women and what control they will have in the situation of an unplanned pregnancy. And for the court to reverse course now, I think would run counter to that societal reliance and the very concept we have of what equality is guaranteed to women in this country.
It is certainly true that there can be some planning by some people about pregnancy. People who are raped don't have a choice, whether it's by an outsider or their own husband. And not everybody can afford contraceptives, contrary to your adversary's brief. In fact, 19% of the women in Mississippi are uninsured, so they don't have money to pay for contraceptives. So, but why their point in their brief was, contraceptives, if you use them the failure rate is very small, et cetera, how can there be real reliance? So could you address that issue?
Of course. So first, this is not a new circumstance since Roe and Casey. Contraceptives existed in 1973 and in 1992, and still the court recognized that unplanned pregnancies would persist and deeply implicate the liberty interest of women. But I think even on the facts, the state is mistaken here. A contraceptive failure rate in this country is at about 10% using the most common methods. That means that women using contraceptives, approximately 1 in 10 will experience an unplanned pregnancy in the first year of use alone. About half the women who have unplanned pregnancies were on contraceptives in the month that occurred. And so I think the idea that contraceptives could make the need for abortion dissipate is just contrary to the factual reality.
You also mentioned, or maybe it was your co-counsel, that life changes for women after 15 weeks.
That's exactly right, Justice Sotomayor, and I think that this is responsive as well to the questions that the Chief Justice was asking about, in particular, the impact of enforcing a 15-week bar in this case. The court has always looked at that issue by looking at the people for whom the law is a restriction, not those for whom it's irrelevant. So the question is, why would women need access to abortion after 15 weeks, and what is the effect on them? And there are any number of women who cannot get an abortion earlier. They don't realize that they're pregnant. That's especially true of women who are young or don't haven't experienced a pregnancy before, or their life circumstances change, as you referred to, Justice Sotomayor. They lose their job, or their relationship breaks apart, or they have medical complications. Or for many women, they don't have the resources to pay for it earlier. It takes time for them to raise the money or make the appropriate logistical arrangements to be able to take time off work and travel and have childcare. And for all those women in this category who need access to abortion after 15 weeks, the fact that other women were able to exercise their constitutional rights does nothing to diminish the impact on their liberty interests in forcing them to continue with that pregnancy.
Thank you.
General, following up on that, would that argument be true in terms of viability as well? In other words, your discussion of the reliance interests and the ability of women and men to control their lives in reliance on the right to an abortion, the argument would not be as strong, I think you'll have to concede, given what we're talking about, which is not a prohibition, it's a 15-week line. Is that right?
Yes.
You have to hypothesize people who have planned their lives according to a 24 or whatever week limit it is, but not a 15-week limit on abortion, right?
Well, I don't think the court has ever analyzed reliance with that kind of parsing. I think here the force of the viability line is that it's clearly demarcated the scope of a woman's protected liberty interest in this context. And the state is not actually asking this court to replace it with a clear 15-week line that would provide some measure of continued protection for this right. They're asking the court to reverse the liberty interest altogether or leave it up in the air. And if that were to happen, then immediately states with 6-week bans, 8-week bans, 10-week bans, and so on would seek to enforce those with no continued guidance of what the scope of the liberty interest is going forward.
Well, that may be what they're asking for, but the thing that is at issue before us today is 15 weeks. And I just wonder what the strength of your reliance arguments, which sounded to me like being based on a total prohibition, would be if there isn't a total prohibition. And as far as viability goes, I don't see what that has to do with the question of choice at all.
Well, I think as Casey emphasized in reaffirming the viability line, the court justified that as having both a logical and a biological justification, that it marks the point in pregnancy when the fetus is capable of meaningful life.
No, that's what John Hart Ely explained was a complete syllogism. That's the definition of viability. It's not a reason that viability is a good line.
Well, it's focused on the idea of fetal separateness, and I think that that is a line that also accords with the history and tradition in this country of abortion regulation. Contrary to the state's arguments here, at the time of the founding and for most of early American history, women had an ability to access abortion in the early stages of pregnancy, and it was only when the fetus was deemed sufficiently separate the states could act to bar that. So I think that the viability line also aligns with history and tradition in that respect.
Justice Thomas?
You heard my question to counsel earlier about the woman who was convicted of criminal child neglect. What would be your reaction to that as far as her liberty, and whether or not the liberty interest that we're talking about extends to her?
Well, Justice Thomas, I have to confess that I haven't read the specific case you're referring to, but if I understand the question you were posing, it sounds as though the state is seeking to regulate for a child that's been born that was injured while it was inside the womb. And I think that we are not denying that a state has an interest there. We're not denying that a state has an interest here either. Roe recognized that states have interests that exist from the outset of pregnancy, but with respect to this specific right to abortion, there are also profound liberty interests of the woman on the other side of the scale, and not being forced to continue with a pregnancy, not being forced to endure childbirth, and to have a child out in the world. And the state's arguments here seem to ask this court to look only at its interests and to ignore entirely those incredibly weighty interests of the woman on the other side.
Thank you.
Justice Breyer? Justice Lee? No? Justice Gorsuch? Anything further?
I just want to make sure I understand your response to the Chief Justice. If this court will reject the viability line, do you see any other intelligible principle that the court could choose?
Well, I think that it would be critically important, even if this court were to reject the viability line, to reinforce and reaffirm the fundamental and profound liberty interest at stake here. And
I'm sorry for interrupting, but that wasn't my question. I understand that point fully by the end of this argument. That is deeply clear to me. I understand your position. I'm just asking a question about whether you think there would be another alternative line that the government would propose or not. You emphasized that if 15 weeks were approved, then we'd have cases about 12 and 10 and 8 and 6. And so my question is there a line in there that the government believes would be principled or not?
I don't think there's any line that could be more principled than viability. I think the factors the court would have to think about are what is most consistent with precedent, what would be clear and workable, and what would preserve the essential components of the liberty interest. And viability checks all of those boxes and has the advantage as well as being a rule of law for 50 years.
Thank you. That's helpful, counsel. Appreciate it.
Justice Kavanaugh?
You make a very forceful argument and identify critically important interests that are at stake in this issue, no doubt about that. The other side says, though, that there are two interests at stake, that there's also the interest in fetal life at stake as well. And in your brief, you say that the existing framework accommodates, that's your word, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue is hard, is that you can't accommodate both interests. You have to pick. That's the fundamental problem. And one interest has to prevail over the other at any given point in time. And that's why this is so challenging, I think. And the question then becomes, what does the Constitution say about that? And I just want to get your reaction to what the other side's theme is, and I've mentioned it in my prior questions. When you have those two interests at stake, and both are important, as you acknowledge, why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? And there'll be different answers in Mississippi and New York, different answers in Alabama than California, because there are two different interests at stake, and the people in those states might value those interests somewhat differently. Why is that not the right answer?
Justice Kavanaugh, it's not the right answer because the court correctly recognized that this is a fundamental right of women. And The nature of fundamental rights is that it's not left up to state legislatures to decide whether to honor them or not. And it's true, different rules would prevail throughout the country if this court were to overrule Roe and Casey, but what that would mean is that women in those states who are refusing to honor their rights and who are forcing them to continue to use their bodies to sustain a pregnancy and then to bring a child into the world will have no recourse other than to travel if they're able to afford it, or to attempt abortion outside the confines of the medical system, or to have a child even though that was not the best choice for them and their family.
Thank you. Justice Barrett?
I have a follow-up to Justice Kagan's question about reliance. I'm just trying to nail down, and I asked Ms. Rickleman this question too, but I'm not sure that I fully understand the government's position or Ms. Rickleman's position. So on pages 18 and 19 of your brief, you talk about reliance interests, and you quote some of the language from Casey about a woman's ability to participate in the social and economic life of the nation. And I mentioned the safe haven laws to Ms. Rickleman, and it seems to me I fully understand the reliance interests. They're the airy ones Justice Kagan was referring to, and then they're the more specific ones about a woman's access to abortion as a backup form of birth control in the event that contraception fails, so that she need not bear the burdens of pregnancy. But what do you have to say to petitioner's argument that those reliance interests do not include the reliance interests of parenting and bringing a child into the world when maybe that's not the best thing for her family or her career?
I think the state is wrong about that, and I think where the analysis goes wrong in reliance on those safe haven laws is overlooking the consequences of forcing a woman upon her the choice of having to decide whether to give a child up for adoption. That itself is its own monumental decision for her. And so I think that there's nothing new about the safe haven laws, or at least nothing new about the availability of adoption as an alternative. Roe and Casey already took account of that fact, and I think that there are certainly, of course, all of the bodily integrity interests that we've referred to, but also the autonomy interests retain in force as well.
Okay, so it's the reliance interests in the right to be able to choose to terminate the pregnancy rather than having to terminate the parental rights.
I think that is part of it, yes, and I think for many women that is an incredibly difficult choice, but it's one that this court for 50 years has recognized must be left up to them based on their beliefs and their conscience and their determination about what is best for the course of their lives.
Thank you, General.
Thank you, General. Rebuttal, General Stewart.
Thank you, Mr. Chief Justice. I'd like to do my best to make 3 points. First, picking up where you just left off, Justice Barrett, on safe haven laws. The respondents in this case, I believe, as Your Honor pointed out, have emphasized parenting burdens being a lead or the lead reason that women seek abortions. I would emphasize safe haven laws, as best I've been able to find, first came into existence in 1999 in Texas. They're now ubiquitous, and you're correct, Justice Barrett, that they relieve that huge burden. I would also add that as to burdens during pregnancy, I would emphasize that contraception is more accessible and affordable and available than it was at the time of Roe or Casey. It serves the same goal of allowing women to decide if, when, and how many children to have. And I would also note, just frankly, the lowest cost abortion at Jackson Women's Health is $600 for the abortion. Additional costs and further fees. According to my friends, the respondents and their amici, there are also additional costs related to travel, taking off time off of work, accommodations, all of those sorts of things. Whether somebody is uninsured or not, the costs of contraception are consistently significantly less than those. Number two, I think, Justice Kavanaugh, you had it exactly right when you used the term scrupulously neutral. I think that's a very good description of what we're asking for here. I think it's the problem and the value that has evaded the court and will continue to evade this court under Roe and Casey, but that is exactly right. This is a hard issue. It involves, and I would emphasize, Your Honor, that, as you said, there are interests here on both sides. There are interests for everyone involved. This is unique for the woman. It's unique for the unborn child, too, whose life is at stake in all of these decisions. It's unique for us as a society in how we decide, if the states get to legislate on this issue, how to decide and how to weigh these tremendously momentous issues. In closing, I would say that In his dissent in Plessy versus Ferguson, Justice Harlan emphasized that there is no caste system here. The humblest in our country is the peer of the most powerful. Our Constitution neither knows nor tolerates distinctions on the basis of race. It took 58 years for this court to recognize the truth of those realities in a decision, and that was the greatest decision that this court ever reached. We're running on 50 years of Roe. It is an egregiously wrong decision that has inflicted tremendous damage on our country and will continue to do so and take innumerable human lives unless and until this court overrules it. We ask the court to do so in this case and uphold the state's law. Thank you, Your Honor.
Thank you, General. Counsel, the case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
Cut to the chase, and that is a 15-week-old baby. Now, let me ask you a question. If you were part of the NASA Mars lander team, and the Mars lander sends back that image from Mars, by show of applause, how many of you would say there is life on Mars? Listen, we have got to get the law to catch up with the technology. Remember going back to 1973, there were 9 men in black robes that decided that the right to abortion is somehow protected by our Constitution. How many of you think that was the right decision? What is protected are 2 things that are very clear. First, we can be thankful here in America that we can have a voice in protest, and frankly, we can be thankful there are others that can voice opposition. That right is protected in the First Amendment. We can stand here freely in this great nation and have a vigorous debate about this issue. What's also protected is the right to life. That is very, very clearly enumerated by our founding fathers. That is why the right decision for the Supreme Court to make in this polarizing moment in American history is to return this debate back to the states and the state legislatures. That is where it belongs, because 80% of the American people, 80%, do not support late-term abortions. Those 9 men in black robes in 1973, they got it wrong. It is time today to get it right. And if you've been listening to the oral arguments today, I know many of you are out here, so you're probably not hearing. I was back in my office minutes ago listening to Justice Roberts, who was questioning, is America on the right side when China and North Korea allow late-term abortion? Thank you, Justice Roberts, for asking that question. And let me tell you something. Justice Kavanaugh, who I'm very grateful I had a chance to vote for Justice Kavanaugh, vote for Justice Gorsuch, and vote for Amy Coney Barrett. You heard Justice Kavanaugh ask the question, doesn't this really belong to be decided back in the states? So I know many of you are praying diligently for this moment. Our prayers have been answered that we now have a case before us where not only will the court uphold the Mississippi law, but the court is going to overturn Roe versus Wade. And this will be a great moment for so many across our country. So thank you. I want to thank you for your prayers, for being here today, for showing up, for Marjorie Dannenfelter from SBA List is right here in front of me as well, and so many pro-life organizations around this country. Last night we were here with the Students for Life. How many Students for Life are here? Let me tell you, it's easier to be out here when it's warm. Last night it was cold, and they were here, and I'm just so proud of them. And lastly, let me say this. We're the grandparents of 2. Our daughter Annie is due with a new little baby on Friday. What an amazing gift that we can give to this next generation and the generation to be born by protecting their lives. Thank you, and God bless you.
Thank you, Senator Daines. Thank you so much for reminding the media what 15 weeks is for. Guys, you can't see this, but the pro-life movement showed up in mass. It goes all the way down the street, all the way across. I would say it's equal size. Now we just want equal rights, right? Let me introduce you to a guy who understands that argument, fights for it every day here in Washington, D.C., Senator James Langford.
Thank you very much. Over here. Hey, it's great to see this amazing group of people, just a sea of folks that are over here. How many of you were here last night freezing? Let me see your hands. Listen, there were so many folks that are out here. Thank you for being here. Thank you for standing up for life. Thank you for speaking out. For all of you that are grown-up fetuses that are here, thanks for being out here saying, hey, I used to be 15 weeks old and look at me now. Thank you for being here and for standing up for one of the most obvious things that is out there. When you look at a picture of a child in the womb, there is no doubt you're looking at a human being. Children are not an inconvenience. Children are beautiful and are valuable, and every single person across this child was once in the womb, including every person on this side that's denying the right of the next generation to be alive. They were once in the womb as well. And so we are grateful to be able to have folks be out here. It's interesting to me the argument that's going on right now to say, let's just have abortion after viability. Now, and then we'll block it before it's viable. Then after that, then we won't allow it. So here's my statement that I heard from my mom growing up. There was this old saying that was out there, maybe you've heard, you can't be a little bit pregnant. What they're trying to say is, oh, you can be a little bit pregnant, and while you're a little bit pregnant, you can have an abortion, but later you shouldn't be able to have an abortion. Listen, my mom was right. You can't be just a little bit pregnant. You're either pregnant or if you're not pregnant, and if you're pregnant, that's not tissue in you. That is a baby that is worth protecting, and that is a life. So for all the folks making the argument about a little bit pregnant, I just smile at them and say that doesn't work, because we all know positive on a pregnancy test means positive for a child that is there. And we're grateful to be able to help stand for, protect, speak out for the life of that child. Listen, our nation has been through instances like this before. Our country once called certain people 3/5 of a man. We did that. But we've also said that was wrong, and we've turned away from that. Our nation, and I see just a sea of ladies that are here, 101 years ago, none of the ladies that are in this crowd could have voted, but our nation said that's wrong, and we changed that. Our nation during World War II rounded up Japanese Americans and put them in camps. Our nation did that, but we came back and said that was wrong. 48 years ago, folks in this building said every state mandated must give the ability for people to kill their children. 48 years ago, we need to step out now and to say we were wrong, and that needs to change now. For all of you that have not given up hope, for all of you that are now living in the post-Roe generation just in a few months from now, this conversation will continue. It's one thing to make abortion illegal. It's another thing to make it unthinkable. And for us to be able to hold up the life and the value of that child and to say, this child's not inconvenient. This child is beautiful. So thanks for standing up for them. Thank you for what you're doing and being here.
Thank you so much, Senator Langford. All right, team. Oral arguments have concluded inside the court. We are just waiting for the visual of Attorney General Lynn Fitch to come out. And when she does, okay, I need all signs in the air, and we're going to chant the sign here: empower women, promote life. When she comes out, so she sees and hears a ton of support. Guys, she's going to come right out and come right to us, which is so great.
All right,
so,
we are joining us back out live here in front of the Supreme Court. As the President just said, arguments have, oral arguments have wrapped up.
Thank you so much.
What lasted, Father Frank, for just about, 2.5 hours. We knew it was going to be a little lengthy on this until the Attorney General comes out. What's your thoughts on what you heard so far?
I'm very encouraged by what I heard. A lot of the predictable arguments back and forth. As we mentioned prior to the arguments, questions about Planned Parenthood versus Casey and undue burden. Overall, I'm very encouraged. I think that the Chief Justice was very good, and of course, a lot of people were wondering, about him. But he raised some very, very crucial points about this case. I thought that, of course, Justice Breyer was the main one arguing on the other side of this. But I found that the arguments of the other side were very weak. And as we predicted, all they did was to regurgitate what's in Roe and in Casey. They didn't bring up anything new. And in fact, they said, let me see, I have some notes here. Justice Kagan said, quote, "Not much has changed since Roe and Casey." Well, that is completely absurd thing to say. A lot has changed, and if she read even a fraction of the briefs that have been submitted to this court, they're filled with the evidence of things that have changed. But because they think nothing has changed, and because they think abortion is a fundamental right rooted in the Constitution, well, then their arguments are going to be always the same. Now, our arguments are the same in the sense that we believe there's a right to life that the state cannot infringe. But the circumstances have changed dramatically as far as how a woman in this country can bear a child and at the same time advance both in her education and her professional life. And one does not have to be pitted against the other as if they have to choose. There's a saying of the pro-life feminists, refuse to choose. Refuse to be put in a position where you think you have to choose between your own advancement and the life of your child.
We've heard so much misinformation about what happens to the women after an abortion. It seems like they leave a lot of the negative after effects of that away from this discussion, and they, it's like a rotating conveyor belt of women coming in these abortion clinics, not looking at the long-term effects, what it does to a woman.
Yeah, they completely dismiss those after effects of abortion, and that's one of the things that has changed. Not how much abortion harms women, but the evidence we've gathered that it does. I mean, people can just, search for, not just the surveys, but the studies that have been done on the physical, and earlier we were talking a little bit about the emotional consequences of abortion. We know more about that than ever before. And that material is all public material, and it's been presented to this court.
Yeah. And of course, you've been watching the coverage here, and it is a huge turnout today, really on both sides. But if I had to gauge, the majority of the crowd here is the pro-life crowd here in front of the Supreme Court. And of course, we were here November 1st for the Texas Heartbeat Act. Same type of turnout then, but today, Frank, much more turnout for pro-life.
It's the biggest. I've been out in front of this court for a lot of the abortion cases. This is definitely the biggest turnout.
One of the biggest questions I've seen on social media so far is, what are the chances of the court today reversing Roe versus Wade? Is that a logical question that we can ask? Could that happen today? I know a lot of people, that are casually watching this case, they want to know, could this be reversed today? Is that possible?
Well, they will not decide today where they come down on this case. They're going to meet on Friday. So the day after tomorrow is an important day to continue praying. And then, so Friday it may be decided.
Yeah, that's
They're going to argue back and forth that they could theoretically, a justice could change his or her vote over the coming weeks.
And we knew that this would run a little long today. There's a lot of, this is probably one of the most heated discussions that we have in our culture today is abortion. I would probably say second of that would be the right to bear arms, your right to gun rights in this country. Does this surprise you that this is on the table right now in our current cultural environment, that we are wanting to discuss abortion and really the right to life in this country?
It's inevitable that this come to a head. It's inevitable. And that we get beyond this idea that, everything is still always the same. No, it's not. And so this day was always coming. And it sounds like the Attorney General is out of the court.
Yeah, let's go ahead and bring it back to the podium here real quickly.
What an amazing day, right? Thank you all.
very much for being here. This is incredible. You can feel the compassion, the love of God who has us here to protect those unborn children and their mothers. Thank you for demonstrating hope for a better tomorrow, for the love and the compassion that we have for the women and their children who deserve better than abortion. You know, over the past 50 years, our world has changed. Technology's changed, science has changed, and certainly we know that life can be detected in the womb much earlier. As things have changed, the roles of men and women have been altered. The workplace has changed, all for the positive. It's been much easier for women to balance their professional life and their success at home. But society has made those changes, but yet with Roe v. Wade, we've not been able to incorporate those changes. But now, hopefully, we can. Roe v. Wade made it impossible. It is time that our laws caught up. No question about it. This gives us the opportunity for the first time to have the strong dialogue about protecting our unborn precious children and their mothers. You know, as a single working mother of 3 beautiful children, I completely understand. I know it's going to be hard. We've still got some challenges. But now for the first time, we recognize that it's time for our laws to move with society and make it much easier for our mothers to be successful. You know, this is a wonderful opportunity to return this to the people, to us, all of us, the people. The Constitution gives us the right. We are ready and willing and able to do the job. Returning it back to the states to have the abortion policy-making decision to us, to the people. And again, we are so prepared for that. You know, it's been a long time coming. We know there are hard choices and there are no easy answers. But for the first time, we truly are having the conversation of how we make it in a positive way for the mothers, for their children. And so I thank you for all the hard work that each of you have done. This has been a tremendous team effort. And I thank you for the hard work you're going to continue to do in a post-Roe v. Wade world. Thank you for supporting women who are going to have to make tough, difficult decisions. Thank you for working with your elected leaders, your elected legislators and governors to make sure that laws are passed that both empower women and promote life. Thank you so very much. May God bless each of you.
All right, and before they leave, I just want to give another round of applause for Lynn Fitch and the Solicitor General, Scott Stewart, who argued inside the court. Give him a round of applause. Thank you, Scott. Thank you. All right, guys, the show's not over. We've got some amazing speakers. I want to introduce to you next a gentleman who has worked incredibly hard for life. Representative Wicker, join us here on stage. Thank you.
Thank you very much, and thank you, Lynn Fitch. Is she a great representative of women? Is she a great representative of the state of Mississippi? For 3 decades, the state of Mississippi has been a pioneer in the fight for life. We led the fight to say you can regulate clinics. We led the fight to say you can have a waiting period. And today, a Mississippi case makes it to the Supreme Court and has been argued the best it possibly could. Thank you to the legislators of Mississippi and to our Attorney General. My wife, I'll speak briefly. My wife is here. She and I have 8 grandchildren. This is a picture of our youngest grandchild, Julia Vaughn Wicker, at 21 weeks. This baby, this American baby, deserved protection, and that's what we're about today. I think we've got some people here who believe the Bible. I won't point to anybody, but some of you know Hebrews 12:1. We are surrounded by a great cloud of witnesses. Therefore, let us run the race with perseverance. There are people who could not be here today. They're part of that great cloud of witnesses. Henry Hyde is part of that great cloud of witnesses. Susan B. Anthony, pro-life Democrats like Harold Volcker. Nino Scalia is part of that great crowd of witnesses today. My colleague Jay Dickey of Arkansas is part of that great crowd of witnesses. Since we're surrounded by them and since the Bible says so, let's keep running the race with perseverance and let's win the race for life. Thank you and God bless you all.
Wonderful. Thank you so much. Now, how many here, when you were typing Mississippi in social media today, said MISSISSIPPI? Thank you to our teachers. I'm introducing you now to Senator Cindy Hyde-Smith from the great state of Mississippi.
Thank you so very much. And you know, today I look out here, I cannot be prouder than being from the state of Mississippi today. What a great day for our state. I'm looking at a lot of women out here, but today we're all Esthers. We're all here for a time such as this, and we are prayed up. It has happened. This is our day. I have the great honor to introduce to you the representative that wrote the bill, the Dobbs bill. It is her bill that they just heard in this building right now. Lynn Fitch, our first female Attorney General, has presented this so well. The preparation has paid off. But right now, Representative Becky Curry from Brookhaven, Mississippi, please welcome her bill. Here she is in person.
Thank you so much. Thank you. It is so heartwarming to see everybody here. There's days in the legislature, I'm a registered nurse who once delivered a lot of babies. And I wonder, what am I doing in the politics in the legislature? And I can tell you today, I know, because we're going to save millions of babies' lives. And I'm so proud to have written that bill. And thank you so much for your support.
Thank you. Guys, the Gestational Age Act, this 15-week bill was penned by Representative Curry, a female, a mom, a nurse. We've got AG Lynn Fitch. I mean, women rock. We're doing great. My little girl in my belly's doing great. I know we're getting close to lunch, so I hope you're doing okay. We're so excited. We have a couple more speakers. Stick with us, guys. I'm so grateful for Representative Trent Kelly is joining us next right here. Thank you.
Thank you very much. And let me just say, life is our most precious gift from God. In the Constitution or the preamble, it says life, liberty, and the pursuit of happiness. In the order that they're important, life first. You cannot do the others without life. And I've chosen to protect this great nation in both life and liberty by serving in uniform. I've served as a district attorney and preserved lives of those innocently taken. And I continue to serve here in the House of Representatives to protect the right to life. I will do all I can to protect that. It is an honor and a privilege to join you this morning to ask the Supreme Court to overturn and reevaluate Roe versus Wade and restore a state's constitutional right to enact laws that represent the will of its people. But I think there's nothing that's more important than Psalm 139:16 when you're asking, is it a baby? Is it a life? And it says, your eyes saw my unformed body. All the days ordained for me were written in your book before one of them came to be. There is nothing more clear than that. At 15 weeks, it is a life. It is a baby. I have sworn an obligation to protect that. It is not right to take that, and I hope our Supreme Court follows the science, follows the technology, and follows the laws of the land and the laws of God, and they understand that at 15 weeks, it is a life, not someone's choice to take. With that, I thank Attorney General Lynn Fitch, who is my friend, my entire Mississippi legislature, our governor, and everyone else involved. But Lynn Fitch is the right face and the right voice at the right time to overturn Roe v. Wade. Thank you, and God bless you all.
Thank you. Thank you so much. All right. We're welcoming someone up next who brought in hundreds, thousands, who has trained so many. If you're with Students for Life, let me hear you. Please welcome Kristen Hawkins, President of Students for Life of America. Should I stand on this? Sure, go for it. It'll help.
Hello, I am Kristen Hawkins, and I am proud to say I'm the President of Students for Life of America. With more than 1,250 groups in all 50 states, more than 130,000 trained activists, we were founded 15 years ago as a post-Roe organization, dedicated to protecting life in law as well as in service, which is why you will find the survivors of legal abortion, all of us who were born after 1973, you will find us daily in state capitol buildings advocating for the laws to end this violence, on campuses and online, challenging the culture to change minds, and in communities, knocking doors, connecting women and families in crisis with non-violent resources and post-Roe initiatives like our own Standing With You program. The pro-life generation is here today in support of Mississippi's efforts to defend law, defend life. We are here. Each and every one of us who are here, who were born after 1973, to say we survived the Supreme Court's disastrous decision. We survived. And we are here for our brothers and our sisters who did not. We are here to directly confront the legal atrocity of Roe versus Wade and Doe versus Bolton. Today we are so honored to be next to Attorney General Lynn Fitch and the state of Mississippi, who bravely come before the court to tell them to do the right thing, to acknowledge the science, follow their hearts. Thank you, A.G. Fitch, for having the courage to fight, for having the courage to stand. Thank you for helping us confront the flawed legal foundation of Roe, Doe, and Casey. Earlier this year, Students for Life and Human Coalition Action filed an amicus brief here at the court. We, the pro-life generation, argued, we stated, we adamantly reject any pretense that women must rely on abortion to further their circumstances or life. As the head of an organization primarily powered by women, many of us moms, we are a working generation of women who've been most targeted by the abortion industry. I've witnessed the misogyny of Roe and Casey decisions and the lies the abortion industry tells women that we cannot succeed without sacrificing our children. The Supreme Court's dangerous and erroneous conclusions made by 7 men about what women need has harmed an entire generation of women who deserved support, not the devastation of abortion. That is why to you today, I am honored to say that we, the pro-life generation, were born, and we are here to declare that we are the post-Roe generation. We are the post-Roe generation. We are the post-Roe generation. We are the post-Roe generation.
Thank you, Kristen. Thank you for everything you're doing. Let me introduce you guys to Catherine Jean Lopez. You may be reading her writing. She's a senior fellow at the National Review Institute. Welcome, Catherine.
Thank you. I'm from New York City. Anybody from New York? I just want to say I love Mississippi today. So grateful. Do you know about the Sisters of Life? They're always here at the March for Life. We love the Sisters of Life. They're Catholic nuns who lay down their lives to serve women and babies and families. They vow to protect and defend the sanctity of human life. They embrace women who are pregnant and feeling like all the pressures in their lives are insisting on abortion. They love these women. They don't tell them not to have an abortion. Rather, they reflect back to them the beautiful gifts they are and the tremendous love they're capable of. The Sisters of Life meet women and girls who are scared. These women and girls often feel like they have to have an abortion so as to not disappoint their families and just about everyone else in their lives. Meeting the sisters frequently changes things for these women, giving them room to breathe. Roe v. Wade hurt these women who feel pressured to abort their unborn babies. It created a right out of nowhere to abort an unborn baby during all 3 trimesters of pregnancy. Roe versus Wade has immiserated women. It has set an expectation for abortion. Roe versus Wade has encouraged a culture where abortion is preferred. Abortion is not empowerment. Abortion severs the most intimate relationship there is between a mother and a child. Abortion is violence. Roe itself is not just bad law. It's not just bad science. Roe is cruel to women and children and men of all culture. It is good for men to be good to women. It is good for women to be able to rely on men. We have different gifts and complement one another. But the regime of Roe versus Wade that was recklessly imposed by this court on the women and men of the United States a near half century ago created a culture that seems to prefer abortion, the most intimate violence there is. This case today, Dobbs versus Jackson Women's Health, is about human rights. This case today is about the dignity of women. This case today is about saving lives. This case is about declaring that women deserve better than the misery and brutality of abortion. It is only euphemisms that keep us from realizing the grave evil that is Roe versus Wade. We pray today that the court comes to its senses and does the right thing and puts an end to Roe v. Wade, which is the real war on women, moms and their children and families. And no, we stand today as a movement who stand with the Sisters of Life as a pro-love movement with over 2,700 women care centers and so much more who embrace women for life. Thank you. God bless you.
Thank you. Thank you. All right, pro-life movement. Attorney General Lynn Fitch loves you so much. She's still here with Scott Stewart, who argued. She's just soaking this all in. So I want to hear you one more time. She didn't get to hear it, but let's together. Hey, hey, ho, ho. Roe v. Wade has got to go. Hey, hey, ho, ho. Roe v. Wade has got to go. Hey, hey, ho, ho. Roe v. Wade has got to go. Hey, hey, ho, ho. Roe v. Wade has got to go. Nice job. I told you this before, but Lynn Fitch, in her brief, called Roe egregiously wrong. That's your 10-point Scrabble word. It's egregiously wrong, and we can't wait for it to be overturned and done with. I'm going to introduce you to 2 more speakers. The next is Gloria Purvis. She stands for Racial Justice, an amazing pro-life leader. Welcome, Gloria.
Thank you. All right, let's see. I'm going to stand on this.
Go for it. I got you.
All right. All right. When I say we must empower women, I want you to say, promote life. Empower women. Empower women? Look, after 20 years, more than 20 years in the pro-life ministry, including counseling women outside of abortion clinics, I have heard many women and girls talk about why they aborted. You want to know why? Coercion, abuse, manipulation, and hostility toward pregnancy were frequent themes. I tell you, we must empower women. I have heard and witnessed a variety of situations. A husband threatening to beat his wife to death if she dares to remain pregnant. A mother or father forcing an abortion because they believe it is best for their daughter's future. A family threatening to expel the woman from the home if she does not abort. A boyfriend offering marriage in exchange for the abortion and then dumping the woman after the abortion. A private high school responding to pregnant girls with threats of expulsion. A college not offering practical resources for pregnant women. And a well-to-do husband preferring the expense of a new luxury car rather than welcoming a child. I tell you, we must empower women. Given my experience with women who have been coerced, manipulated, and abused because of abortion, I see overturning Roe as a means of justice for these women. Look, the truth is, abortion does not liberate women from the patriarchy. It simply severs a man from his obligation to the mother and their unborn daughter. Look, this does not teach men to love and respect us, nor their unborn daughters. It enables men to defile women and encourages them to abuse women verbally and otherwise. Look, abortion is integral to upholding systems that oppress women. We must empower women and... Look, imagine the law, businesses, educational institutions, the military, the economy, the very structure of our society not having abortion as a buttress. Imagine our world making way for women truly as we are, and injustice giving us what we are due because of our womanhood. We must empower women and... Look, this is not just financial and material support, but a wholesale rethinking of our attitudes, practices, and systems in our society and the church. A society that cherishes women, offers support for women and girls, whether pregnant, mothering, or not, and rightfully binds the father to support the mother and his child. We must empower women and... This new vision could include rights that encourage and enable women's full participation in education, business, and industry. Rights that change our vision of work so that accommodating working women and mothers is not a concession, but an essential aspect of a successful business. Rights that ensure workers receive just wages to support a family. Rights that protect future women and men in the womb. Rights that provide authentic women's health care, including prenatal health care, maternal health, and postmenopausal care. Rights that bind the father to the mother and to his daughter, including unborn daughters. Rights that create a society where structures protects women and the culture would not brook our abuse, verbally or otherwise. We must empower women and...
Great job. Guys, I know since... Is my voice cracking? I lost my voice. I'm glad that you've lost your voice because, again, you're speaking up for those who don't have a voice. I'll gladly lose my voice for these children. We've been talking this morning about the other side and how we want them to join us in this fight for life. How if they could join us in this fight for life, lives would be saved, women would be empowered, workplaces would change, and we could then move on and fight other human rights abuses, right? I'd love to do that together. We now have our last speaker, someone who truly has left the other side. She was a former Planned Parenthood director, and she is now a member of Democrats for Life. Please give a round of applause for Maya Rodriguez.
Thank you. You won't believe that last time I was standing here, it was along with Planned Parenthood, along with Cecile Richards, fighting for Planned Parenthood. What a change for me, right? That was barely in 2017. I'm the former Planned Parenthood director and whistleblower from the state of Arizona. I worked for Planned Parenthood for 17 years, thinking I was helping women. In 2017, I was named the director of the biggest abortion clinic in the state of Arizona. And what I saw there changed my heart and mind about abortion. I saw the complications and I saw women getting hurt. I saw the falsifying of patient charts. I saw the perforations done daily to women unreported. I saw the incomplete abortions. I saw the abortionists leaving baby parts and then refer to them as trash. And refuse to go back and look at the woman and correct his mistake. So what happened? I got fired. And then I sued Planned Parenthood in the state of Arizona for wrongful termination under the Whistleblower Protection Act. And we won. And today my mission is to tell women abortion hurts you. I was there. I was selling you abortions. Abortions are not for women. I heard the other side say something like, sí se puede. Sí se puede not have abortions. Sí se puede to empower women. Sí se puede have children. And be a lawyer. And be doctors. You know, working for Planned Parenthood, I was told to be pro-life, you have to be Republican and white. I've been lied. Because I came out, and there's a lot of pro-life Democrats. There's people from all over races. There's people from different religions and beliefs. There's atheists. Because the pro-life movement, it's about being really inclusive. And that's including the babies in the womb. Because empowering women, it's caring for those women inside the womb. And we won't stop. And now if you let me, I will do it in Spanish all over again. Gracias a todos por estar aquí. La última vez que estuve aquí fue al lado de Planned Parenthood, peleando por Planned Parenthood, junto con su presidente Cecile Richards. Hoy estoy aquí porque después de trabajar para Planned Parenthood por 17 años, me di cuenta que el aborto lastima a las mujeres. Sí, yo fui parte de esa industria. ¿Y qué fue lo que vi ahí? Cómo las mujeres eran perforadas, cómo las complicaciones no eran reportadas y cómo el abortista fallaba en su trabajo y dejaba partes de los bebés a las que él se refería como basura dentro de esas mujeres. Lo que siguió fue que me despidieron. Demandé a Planned Parenthood ganando una demanda que nunca antes ningún inmigrante había ganado en la historia de este país. Y hoy estamos aquí defendiendo a las mujeres. Today's battle is really important not only for America, but for the world, because we lead the world. The world is looking out for us to do the right thing for the unborn. They are hopeful that we will turn off Roe v. Wade so they won't get abortion in their countries. Because Latin America don't want abortions. They don't want to kill their babies. Latinos, we like big families. That's who we are. That's our culture. Don't kill our babies. We don't want that. We want our big families. It's our culture. Thank you so much for being here. Thank you so much for supporting the unborn. And thank you so much for empowering women.
All right, ladies and gentlemen, that is the end of our program this morning. Give yourselves a round of applause. The real OGs, you stuck it out the whole time. Now listen, this decision is likely to be handed down this spring, so keep these deliberations in thought and prayer. And your work here, no matter what, has just begun. No matter what the court decides, we continue to fight for life, right? In our communities, to our families, to our friends. It can be something as simple, guys, as posting on social media that if you ever find yourself in an unplanned pregnancy, I'm there for you. You might be surprised at what kind of response you get. I want to make sure that you are connected. Follow the organizations here. Get involved. Get plugged in. This is a big year. And if the court does the right thing, we've got a lot of work to do, and we're ready to do it. I know you are. So one more round of applause. All signs up for an amazing morning at the Supreme Court. 1, 2, 3. Thank you, guys. You don't have to go home, but we got to get out of here. So take a sign, take your trash, and I'll see you soon. Keep fighting for life.
All right, we'll back out here live in front of the Supreme Court. As you just heard the announcer there kind of wrap up things here at the steps that started very early today, around 9 a.m. here at the steps. And as we heard the oral arguments inside the Supreme Court on the Dobbs case out of Mississippi, we heard Father Frank Pavone from Priests for Life share his thoughts on what he could perhaps come out of this very historical case that's being heard. Now, this is the first real opportunity for Roe versus Wade to be challenged and overturned right now with the Dobbs case. Now, we were just here about a month ago with the Texas Heartbeat Act back on November 1st. And so now we're back here on this December day doing this as well. So I hope you've enjoyed all of the coverage as we had the audio streaming live from inside, trying to keep up with what was being said inside. I'm sure we're going to have a few moments with Father Frank Pavone. I think he might be getting ready to speak right now. Let me step aside and see if we can get some audio from that.
You guys stick around. We're going to have another hour of a rally. My name is Brian Kemper. I'm the Youth Outreach Director of Priests for Life, and I'd like to introduce Father Frank Pavone.
Okay, brothers and sisters, we have had the arguments in the court. We need to continue in an attitude of prayer. They're continuing their rallies. We're going to continue ours. We haven't had much singing here today. And you know, there's a song called Spirit of the Living God, Fall Afresh on Us. And we can sing Spirit of the Living God, Fall Afresh on them, on the court. And I'd like to do both of those things. I want to ask you to extend your hands to the court. In that ancient gesture of calling down the Holy Spirit, let's extend our hands to the court and sing Spirit of the Living God, fall afresh on them. Spirit of the living God, fall afresh on them. Spirit of the living God, fall afresh on them. Melt them, mold them, fill them, use them. Spirit of the living God, fall afresh on them and on us. Spirit of the living God, fall afresh on us. Spirit of the living God, fall afresh on us. Melt us, mold us, fill us, use us. Spirit of the living God, fall afresh on us. Brothers and sisters, what happened today was not just here. What happened today and is happening is happening all across the country. People are gathering, not only here at the Supreme Court with you, they are gathering at state houses, they are gathering at abortion facilities, and one of the people helping to galvanize those activities is here, the director of the Pro-Life Action League, the son of a pro-life legend and founder Joe Scheidler, Eric Scheidler from Chicago. Eric, come and tell us what's happening today.
Well, it's been an amazing thing to be here with so many thousands of people all across the United States. I want you guys to know that this is not the only rally taking place today. There are over 100 rallies taking place at cities and towns all over the United States today, calling on the Supreme Court to overturn Roe versus Wade. This is not just a Beltway issue. This is not just a Washington insiders issue. This is an issue for every single American. I also want to call to mind all of those who fought so hard for this day but aren't here with us because they've passed on. People like Dr. Bernard Nathanson, the former abortionist. People like Dr. Jack Wilkie, who was fighting abortion way back in the 60s. People like Mildred Jefferson. Paul Brown, who just passed away. And of course, my late father, Joe Scheidler, who died in January. And for the first time, months before his death, was feeling hopeful the Supreme Court might overturn Roe versus Wade. We are standing on the shoulders of giants. Let's remember them as we celebrate this moment and as we continue to pray that the Supreme Court will do the right thing and overturn Roe versus Wade.
A lot of the arguments that were presented to the court today are the result of the research that pro-life experts have done on the impact of state laws on saving lives. One of the key people in our movement who has done a lot of that research is Dr. Michael New, Professor Michael New, and he would like to say something here as well.
Father Frank, thanks for that very kind introduction. It's great to see so many pro-life people here today. We have been waiting 48 long years for today. We've labored hard, we've prayed, we've educated, we voted.
All right, I'm going to step in here real quickly, and
with a great
I want to offer up a big thank you to our partner for this broadcast, the great patriot himself, Mike Lindell, over at MyPillow.com. I know we've got Christmas coming up. We've got some supply issues around the country. We've got the stress of going to the mall. I just want to suggest that everyone watching this right now, if you like what you hear today and you support the pro-life movement, support Mike Lindell and election integrity, I encourage everyone right now to log on to MyPillow.com and shop away for your gift this next holiday season. Also go to mystore.com as well, thousands of products right there. And keep in mind, when you use that promo code RSBN at checkout, not only will you save up to 66% off your entire order, but you're also helping out this network to cover things that are close to you and I, which in this case is the pro-life movement. So I just encourage everyone right now, support Mike Lindell, support what he's doing over there, and go on to mypillow.com. And don't forget that promo code RSBN at checkout, and you'll get up to 66% off your entire order. We're talking about those great Giza sheets, the classic pillows, the slippers, the dog beds, the mattress toppers, all of that. The travel pillows, which I have one, it goes everywhere with me. So go on to mypillow.com, mypillow.com, put the promo code RSBN at checkout, and get up to 66% off your entire order. Father Frank Pavone's up on the podium. We're going to continue some of our coverage on social media. I will post up some of the speeches, some of the sound from here, some of the sights and sounds around from the Supreme Court here. We'll continue some of that on our social media, so I encourage you to follow us on Instagram, Facebook, Twitter, and stay in touch with all of that. Also, stay in touch with Father Frank Pavone as well, Praying for America, a great program we have right here on our network, and we certainly appreciate him contributing to that, as he is a fighter for freedom. He's a fighter for faith, a fighter for the unborn, and so we certainly appreciate all that Father Frank Pavone does for us. But it's been a long day here so far today. I hope that you have taken away something from this broadcast. And the fact that now is the time to pray for this country. Now is the time to pray for the people that are on the other side of the fence over here, the people that are advocating for pro-choice, that are advocating the death, the killing of the unborn. So I just want to throw that out there and have you pray for everybody involved in today's activities, regardless they're on this side, the pro-life, or the other side. They need your prayers. And we've heard the common theme through all of this is that God will simply will not bless this country unless we protect those lives of the unborn. And so I want to just stress to everyone right now that thoughts and prayers are very important in today's time. We will continue our coverage here at the Supreme Court. The sights and sounds are still thousands of people that are gathered behind us. This is probably one of the largest rallies we've had in a long time, especially in terms of your pro-life. Now, one of the takeaways also was this next couple days going up to Friday and into next week are important, as Father Frank felt like the Supreme Court justice would review what they've heard today, and in fact, this spring we could get some type of overturn on the Roe versus Wade case. So maybe we're just months away from that historic moment. It could happen before then. We're just not quite sure. But we're glad that you joined us here today. And as a reminder, you go to our website, rsbnetwork.com/donate, because we're only able to do things like this because of our partners like Mike Lindell over at MyPillow, and also the great people over at Simple Scrub, thesimplescrub.com. We'll get into that company a little bit later as well. But also viewers like you, viewers that have contributed to this network to allow us to cover not only President Trump during his term and all the midterm elections, but also very important events like this. So I encourage everyone to go on our website, rsbnetwork.com/donate, and simply donate what you can to make it happen. Also, sign up for our newsletter. You can go to rsbnetwork.com, click on the newsletter tab, sign up for it. It takes a few minutes. Put your email in there. You can definitely stay in touch with what we're doing. We have a great team of writers right here at Right Side that put out articles that are very close to you and I. So I encourage everyone to do that. Also, go download our app. Go on our Apple, our Android store. Simply search RSBN. Download our app. It's absolutely free, and it's a great way that you can keep all of this in the palm of your hand and take this show on the road. Red, White, and Troop with Mike Crispy. We got Diamond and Silk. The great Michael Savage is there as well. So I just encourage you to go get that app as well and stay in touch with everything we do. You can follow me on social media as well. I'm going to be out and about throwing up a lot of the images here up on our social media. You can follow me at Brian Glenn TV across the board on Twitter, Facebook, and Instagram. So I'll step aside. What a beautiful shot here in our nation's capital on this gorgeous day. Thank you so much for joining us. Until next time, goodbye and God bless from our nation's capital. We'll see you later, everybody.
A justice can change his or her